9th meeting of the City of Tampa Variance Review Board. From my left, the members of the board are
Susan Long,
Dustin Pastor,
Brett Feldman.
Sam Walker.
Lynn Hertak,
David Farrell.
also in attendance this evening are from legal, Ms. Kamaria Pettis-Mackel, from Development Coordination, Mr. Joel Souza, and Brett Burks, from Natural Resources, Mr. Owen Williamson, and from Transportation, Mr. Jonathan Scott. There are some procedural rules we'll need to follow. All individuals are required to wear facial covering at all times during your visit. Upon entering the building, check in with security guard on the first floor lobby. Please report to the second floor waiting area. A staff member will greet you and check you in for your case. Once checked in, you may take a seat until your case is ready to be heard, in order of the agenda. While in the waiting area, please maintain social distancing protocols. A staff member will advise you of the appropriate time to proceed to council chambers on the third floor. Once inside council chambers, please be seated in the audience area. The chairperson will review the hearing procedures and you will be sworn in. Then the review of your case will commence. Please proceed to the podium to present your case. Please note that the podium area will be sanitized between speakers. When your case is completed, please exit council chambers and proceed to the building exit. Please do not remain in the third floor lobby area. Staff will be directing other participants to council chambers and wants to ensure appropriate distancing is being maintained. If you have questions for staff following the conclusion of your public hearing, please contact the staff member during regular business hours, since the enhanced health protocols limit their availability during the public hearing process. Thank you for your cooperation. When your case number and petitioner's name is called, please approach the podium. When you approach the podium, please state your name, address, and if you've been sworn in. The petitioner and/or their agent will have 10 minutes to make a presentation. Please make sure to clearly state your hardship criteria as submitted in your application. All other persons or participants wishing to speak will have 3 minutes, and then the petitioner will have an additional 3 minutes for rebuttal if needed. The time periods as stated will be kept by the board. Any information such as pictures or plans that have not been previously submitted as part of your petition and you intend to present at this hearing for consideration in support of your petition must be individually presented and accepted by the board. After acceptance by the board, you must submit the item to staff for it to be entered and made part of the permanent public record. The board bases its decisions on competent and substantial evidence which is presented and which meets the criteria required by the city's code of ordinances. The variance granted by the board will only be for what is shown on the site plan and will be in compliance with any terms and conditions stated in the approval by the board. All of the city codes will need to be met. If the case is approved, your variance will expire 2 years from the date of decision. If the case is continued, it will be continued to either next month's VRB agenda or the next available, which in this case is May 11th. If the case is denied, you may wish to have the variance board's decision reviewed or appealed by city council. You must file for a petition for review of the board's decision within 10 business days of the written decision. You will not be able to pull any permits until after the 10-day period has passed. Your cooperation in ensuring that this meeting is run smoothly is greatly appreciated. Will anyone move to approve the minutes? Ms. Long? Second. Mr. Feldman, and a vote please, Ms. Long.
aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hertak, aye.
David Farrell, aye. Thank you. At this time, I'll ask legal staff to confirm any inappropriate communications conflicts.
Good evening, Kamaria Pettis-Mackel from the City Attorney's Office. Will the commissioners state whether or not they've had any ex parte communications regarding any of the items that are listed on the agenda? Seeing nothing for the record. Additionally, will the commissioners please state whether or not they have any conflicts of interest regarding any of the items that are listed on the agenda? For the record, there are no comments from the commissioners. Thank you.
Okay, with that being said, is there any business regarding the agenda that staff would like to address?
Yes, sir. Joel Sousa, Land Development. The following VRB cases will not be heard tonight. VRB 19108. They've withdrawn their case. They will not be heard tonight. VRB 2073 will not be heard tonight. VRB 2109 needs a vote, but they were requested to be moved to the April 13th hearing date. VRB 21,
Actually, I'm sorry, Kamaria Pettis Mackle from the City Attorney's Office. Can we actually handle the cases? Yep,
you want to do that one at a time?
yes.
Okay,
yes.
and we'll stop at that. VRB 2109 has requested to a continuance to the April 13th hearing date.
I
Okay.
move,
Go ahead.
I move that VRB 2109 be moved to be continued to April 13th, 21
At 6:30 PM?
at 6:30 PM.
Brett Feldman, second.
Thank you. And a vote, please.
Aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, aye.
David Farrell, aye.
Ms. Mackle, do we still need to say our names back in these chambers? Or is that a conference center thing?
I think for the clerk purposes, it'll be easier if we continue to say our names.
Okay.
Thank you.
Okay, continue, VRB 2114, misnoticed, they will not be heard tonight. VRB 2115, did not notice, they will not be heard tonight. VRB 2117 is requested to be heard on April 13th, and then you vote.
Okay.
Okay, Brett Feldman, I move that VRB 21-17 be moved to the April 13th, 2021 public hearing at 6:30 PM.
Sam Walker, second.
Okay, and a vote, please.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, aye.
David Farrell, aye.
Okay, that case will be moved to April 13th. And finally, VRB 2118 cannot be heard tonight, so that's coming off the agenda. Okay, VRB 2118. We have 7 cases tonight.
Okay, is there any new business staff would like to address?
Staff has nothing.
This time I'd like to ask staff if we should conduct a swearing.
Kamaria Pettis Mackle from the City Attorney's Office. We're swearing in one application at a time.
Please stand and raise your right hand. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
So our first case for the evening is VRB 2060, continued from November. It's located at 1508 South Arwana Avenue. Are you present? Yes. I'm going to continue to ask that even in this format because we waste a lot of time reading cases when people aren't here. Okay, Mr. Souza.
Yes, sir. The property owners, Chris and Rebecca Kraft, agents, Stephen McNally. The required variance is to reduce the rear yard from 5 feet to 3 feet for an in-ground pool. DRC has reviewed this application and has no issues with it. Let me show you where it's located. Okay, if you see on your zoning map, the property is located right here on Arawana, which is just to the west of Howard Avenue, which is off to your east, and McDill, which is off to your west. This is the subject location. This is Arawana here. This is a picture of the front of the house. The applicant has provided the site plan as you see right here. It's zoned RS50, this residential single family, and they're proposing to put a swimming pool here. Code requires 5 feet to the water's edge from the rear and side yards. Applicant is asking to reduce the rear yard setback from 5 feet to 3 feet. That concludes my report. Staff is here if you have any further questions.
Okay, could the petitioner please step forward, state name, address, and if you've been sworn, please?
Good evening, Steve Michelini. I'm here representing the Crafts and 1508 Arawana, and yes, I have been sworn.
Okay.
If the board may recall, we continued the hearing in order to obtain some additional information that was being requested regarding drainage and the proximity of the pool to the adjacent property owners to the rear. Since that time, I have discussed this issue with the City of Tampa Stormwater Department, and I offer this information in support of the fact that no construction, regardless of whether it's a pool or any other construction, can adversely affect through drainage or stormwater runoff any other adjacent property. And I'm read this from the technical manual from stormwater. Drainage patterns are not to be changed to the detriment of a neighboring property. Notwithstanding the issuance of a permit, the city, by the city, and in compliance with the requirements of Chapter 21, the act of stockpiling, material grading, excavating, or other acts affecting drainage shall not change the surface drainage pattern to the detriment of a neighboring property or the public rights-of-way. And I'll be happy to enter that into the record. You may recall that we had neighborhood supporting letters from all of the adjacent property owners except for the neighbor to the rear that's adjacent that is objecting to this variance. We also had an additional survey done to determine exactly the location of the accessory two-story structure that the neighbors have, and we found that that structure, in addition to the air conditioner, which has been removed, but the structure itself encroaches on the property line according to the survey dated 12/20 of 20. We also contacted the pool contractor who developed a plan, and I'll be happy to show that to you. That's a grading plan, and it also is a drainage plan that shows that there's no water from this site that will be conveyed onto the other site as a result of the construction of the pool. This is the, is there a handheld mic? I guess not. This is the plan showing the 3-foot separation from the edge of the deck to the adjacent property here. And this plan shows you the drainage and flow along with the existing and proposed grade elevations, which are existing and proposed are the same. So the grades will not change on this site that would adversely affect the adjacent property. And you can see the flow arrows. Any grading that occurs will actually occur on 1508 Arawana side to convey the water out to the street, which would be the south side of the property. There we go, thank you. We also have the section drawing showing you existing and proposed grades for the pool itself, and also on the adjacent property that's existing on the fence side, which is here, versus the house side, which is here. In addition to that, there was a statement made that somehow that we were going to affect the structural integrity of the garage apartment on the north side. And when I discussed this with the drainage engineer, also with the City of Tampa Building and Construction Division, they advised me that with careful consideration with the permitting process, that there should be no reason why it would affect the structural integrity of the building to the north. If you may also recall that we had issues that we were talking about regarding elderly care and the individuals that the household had taken on to make sure that they were adequately serviced. I have some photographs here, as well as the ADA requirements for accessibility to pools. This is a diagram showing you, this is 3 feet off of the house, and this is 5 feet off of the house. This is the petitioner's mother with a walker and not a wheelchair, showing you at 3 feet what the accessibility area is versus the 5 feet. And then this is the dimensions of the walker itself, showing you how wide that is. And again, it's a walker, not a wheelchair. And they have 2 elderly parents who are who need wheelchair accessibility. And then according to the ADA, on wheelchair accessibility for pools, they're recommending 60 inches, which is 5 feet, as opposed to 3 feet or less. And that, I can put that in the record as well. And that also includes a wheelchair or accessibility lift that would be placed on the property owner's side nearest to the home and not on the back side closest to the adjacent property owner. In the survey, it showed that the building itself is built on zero lot line, and it may in fact encroach. However, the roof line does encroach onto the 1508 property. This photograph was of the the air conditioner. They cut a hole in and altered the fence to allow the air conditioner. This has since been removed and blocked up. And then this photograph shows you the proximity of the building versus the property line, which is actually on the other side of the fence. Now, previously we had submitted to you all of the information and the support letters from the adjacent property owners. I believe that we have significantly demonstrated that the issues that were raised previously have been addressed. Also, the fact that with the addition of the pool, we will actually be improving the drainage because we'll be removing concrete porches that are in the area that are already existing in the back area, and the pool will replace that. So it's a net zero increase. The construction is approximately 300 square feet of impervious concrete will be replaced with natural stone and pervious decking pavement. I think that I've addressed all of the issues. This condition was not brought on by the property owners. I think we've demonstrated that it does not adversely affect any adjacent property owner. It is consistent with the Tampa Comprehensive Plan, and that, you know, with these changing times, we have to take on additional responsibilities that we didn't plan on taking. And these individuals believe that the best care that they have to provide is in their home for their own family, and not to be additional burdens out on in the community and in the public realm with nursing homes and things like that. So I'll be happy to answer any questions you might have. With respect to this petition, I believe we've met the burden of proof, and we've demonstrated that we are not adversely affecting any adjacent property, and that this is consistent with the code, and we've demonstrated that there is a personal hardship that's been related to this. As I said, I'll be happy to answer any questions you might have.
Thank you. Does that conclude your presentation?
Yes, sir.
Okay. Is there anybody in the audience that wishes to speak on this case? Yes, please come forward.
Let me get my mask back on here. Thank you.
state your name, address, and if you've been sworn.
Good evening, Mr. Chairman. My name is John Grandoff. My address is Suite 3700 Bank of America Plaza. I'm with the law firm Hill, Ward and Henderson, and I'm here representing Barbara and Carrie Toole in opposition to the variance. May I please confirm my time?
Have you
is-
been sworn in?
Yes, I have.
Okay,
My time is 5 minutes?
3 minutes.
3 minutes, okay. I'll start at the last statements from Mr. Michelini. He says this is a personal hardship. It's not what the code says. It has to be a unique condition of the property, not a personal hardship. He says, quote, "The condition was brought on not by the property owners." Doesn't matter. Has to be a unique condition with the property. He says, quote, "There's going to be a net zero increase in drainage." So now Mr. Michelini is a professional engineer who just gave you an opinion on drainage with no substantial information to support that opinion. I direct you not to listen to that testimony. He brings up an elderly care issue, shows photographs, nothing to confirm that the person in the photograph actually has a medical condition. Where's the medical doctor's opinion that this pool is necessary? I wrote them a letter on December 9th, put them on notice, bring the letter, bring the physician, prove this is true. Even if you do, it is a personal condition, has nothing to do with the property. It's not a pie-shaped lot, there's not a tree in the middle, it's not a irregular lot. This is a personal preference. They want a pool for some reason. A pool is a luxury. It's not a necessity. My clients are bearing the brunt of this variance because they're behind them. Yes, they have an existing garage that violates that setback. That is not the test tonight. You don't say, well, the Tools violated the code, so you got to let me violate the code. The Tools building was built in the 20s. It's a vested, non-conforming use and structure. We didn't have zoning until 1956, so can't listen to that tonight. That's not competent substantial evidence. The drainage code is chapter 21. I commend Mr. Michelini's clients to read that closely. Finally, I'm going to give you a case that was recently decided by Judge Barbas in the 13th Circuit, a variance case involving the Port Authority on some docks. A fellow wanted a bigger dock. Why? Because I want a bigger dock. Why? Because I want a bigger pool. Judge Barbas, in this opinion, if I may provide this to you briefly, just a moment. Can you hold my time?
No, excuse me, the podium?
Oh, I'm sorry. That's a good idea. Okay. In a nutshell, a fellow wanted a bigger dock. His neighbor said no. The court said, you're right, no bigger dock. Under Barnard versus Town Council of Palm Beach, an applicant who seeks a variance must demonstrate unique hardship in order to qualify for a variance. This court is unpersuaded by the assertion that everyone in Apollo Beach has what Mr. Caruso requests, a bigger dock. First, the assertion is unsupported by any specific factual references. Second, the standard is not whether variances have been granted to other similarly situated properties or whether granting a variance would have a deleterious effect under the Herrera case. It is whether there is evidence that no reasonable use could be made of the property without a variance. The record clearly shows Mr. Caruso already enjoys more than adequate use of his riparian rights. The record already shows that the Crafts already have adequate use of their property.
See if we can wrap it up in 20 seconds here.
I respectfully request that you deny the variance. No competent substantial evidence to support it.
Is there anybody else that wishes to speak on this case? Please step forward. Mr. Grandoff, mask are required at all times in City Hall.
Let me just, these are the petitioners, so that would be counted as part of my time. But they wanted to address the issue regarding the medical necessity of the pool.
You still had 1 minute left on your clock.
Okay, well, I'll give them the first minute.
I'm Rebecca Kraft. I'm property owner. I have been sworn in. I just, I have my mother who was in that photo and my grandmother, and due to COVID, we have both of them in the house very often. My mother uses a walker due to leg issues. My grandmother uses a walker and a wheelchair. We are trying to improve our property. We are not trying to create a bigger pool than what construction code allows. Should this variance not be approved, we will still, submit a permit for a 10-foot pool in our backyard that would be 5 feet off of our property and 5 feet off of the rear property. We're not trying to make a bigger pool. We're just trying to push it back to enable my family members to pass out of the door and by the pool in a safer manner to improve accessibility and passage and all of this. I don't have her ADA paperwork, but I can provide that to you if that's needed. I am a nurse practitioner, so I am also able to tell you that it is a medical necessity. My brain's not even working right now, I'm sorry. These medical devices that she uses for walking around, we are not asking for anything unreasonable, I don't believe. We're just trying to enjoy the space in a pandemic world with our family so that all of us can enjoy the space together, and that's it.
And Dustin, can I say one thing?
Thank you.
Please state your name for the
My
record.
name is Chris Kraft. The last time we talked as well, you had mentioned that we could put a pool enclosure in there. Look, I don't go in the pool if it's under 84 degrees. The pool enclosure cuts out about 33% of the direct light to the pool. It makes it dramatically cooler. I have no desire to do that. And if you want to put in the variance that we can't put a pool enclosure in, I'm fine with that. My mother, 2 years ago, fell in a pool and broke her ankle, and I had to pull her out, man. Okay? I had to get her out of the pool myself. I don't think I'm going to be able to do that with these people, man. I don't want to go through that again. This is all this comes down to. Please, give us the opportunity to move this back so we can make our pool safer for our family. That's it.
Thank you. Is there anybody else that wishes to speak on this case? Seeing none, let's open it up for board questions.
I think I have rebuttal time, don't I?
Not yet, not yet.
Oh, okay, I'm sorry. It's all right.
All right, I have a couple of questions for Ms. Pettis-Mackle from legal. Ms. Pettis-Mackle, first, are we permitted to rely upon the testimony, the sworn testimony of the petitioners for the ADA issues? Or do we require some sort of documentation for that?
Kamaria Pettis-Mackle from the City Attorney's Office. This is a quasi-judicial proceeding. There's no formal rules of evidence that have to be applied. The standard of procedure is due process in order to ensure due process for the applicant or for anyone who's opposing the variance request. It's up to you to determine what is competent substantial evidence. Is within your purview to determine what is competent substantial evidence. There's no rule within the rules of procedure for the variance review board on what you can and can't rely on. It's competent substantial evidence.
All right, I got it, thank you. Second question. I have heard in the past, from a long while ago, before you were legal counsel, that ADA compliance issues, issues of addressing an ADA, I'm trying to think of how to put this, a petitioner's ADA issues could meet a hardship criteria. Can you give me some guidance on that as to whether if a petitioner is attempting to comply with the ADA, for instance, installing a ramp instead of stairs, could potentially meet the hardship criteria so that the petitioner can't use stairs, so they have to put in a ramp, the ramp has to get closer to a setback. Is there some legal guidance on that?
Kamaria Pettis-Mackle from the City Attorney's Office. Again, I would remind the commissioners that of the hardship criteria. There's no, and I apologize that I can't speak in reference to what happened in the past, so I apologize for that. But I would urge the commissioners to rely on the evidence and the testimony that was submitted on the record regarding the reason for the hardship, the reason for the variance request to determine whether or not the hardship criteria has been met. And those factors, you could use that testimony to determine whether or not the factors have been met as to the reason the variance. Use the testimony and the evidence that was submitted on the record to determine whether or not the hardship criteria has been met for the variance request.
Okay,
The reason for it.
all right, thank you. Mr. Michelini, question for you, sir. I heard you say that the ADA wheelchair accessibility requires 60 inches or 5 feet. Is that accurate?
Yes, sir, that came right off of the webpage.
Okay, and you are seeking 7 feet between the existing structure and the line of the pool? The start point of the pool? I'm looking at your survey.
Let me just pull it up here for a second. 6 feet 4 inches, according to the pool diagram from the
Okay,
pool.
I'm looking at the pool diagram that you've provided us, and does it not have a 7-foot distance between the building and the pool? The purple pool, little 7 in front of it?
I'm looking at the latest plan from the pool.
Can you put that up for us, please? Okay, and there is,
6 feet 4.
and that runs to the edge of the pool?
Yes, sir.
Okay. Why isn't it just 5 feet?
I can't answer that. We went to the pool contractor for verification of the dimensions because there was some discrepancy between what the original survey showed, and I wanted to have exact dimensions for you to present to you. And that's when he came back with this diagram.
Okay. All right. I don't have any other questions. Thank you.
Could it be possible that Mr. Michelini, could it be possible that when the pool contractor was laying out, he took into account the fact that the door width is at least 24 inches each leaf, and when that comes open, it's not really usable space until you get beyond it?
Yeah, there was
So
a,
3 foot would put you on the edge without that extra 2 feet starting from the face of the door once it was open.
well, if you look at the diagram, you can see that there's a door opening there. And that may be very well what he was trying to accommodate, was so that the swing of the door would provide you with a little additional space for safe maneuvering. Starting my presentation and my rebuttal?
They have to determine.
No, that's fine.
Okay.
I'm just asking.
Does anybody else have any questions?
Lynn Hertak, I do have a question. This doesn't have the, wheelchair access part for the pool in here, or the lift?
We didn't show it because we weren't sure exactly, what the board was going to be feeling comfortable with. We could push the wheelchair lift down to this end down here, so that it wasn't between the house and the pool itself. So it wouldn't be affecting the proximity of the pool in relationship to this dimension here between the edge of the pool and the edge of the structure of the house. But our intention was not to obstruct that distance in between.
Are there any other questions? 3 minutes for rebuttal.
I appreciate the objectors mentioning that I wasn't an engineer. I was reading that off of the pool engineer's comments, where he indicated that the pre and post conditions regarding impervious surface were the same. And that came directly from the pool contractor. I didn't make that up. The other thing is that when we're talking about encroachments of property, there's no such thing as vesting an encroachment of one person's property over another person's property. You can't grandfather that in. I mean, if the Crafts wish to do so, they could challenge them and tell them to remove that. It's an improper encroachment. If you're talking about a setback issue that's grandfathered in, and they were within their own property, you could grandfather that in, and that wouldn't be required by the city to be changed. But encroachment is a different issue. We went to great extent to try to relieve any kind of an adverse impact on an adjacent property owner. And I think that we are in unusual and challenging times. I mean, normally you wouldn't come in and say, hey, I need a pool because I want a bigger pool. That's not the case here. They want a pool that is a 10 feet wide, and they want it because they have elderly parents and who are handicapped, and they need handicap accessibility. And we're also challenged by the dimensions for safe maneuvering of a handicap apparatus. So, this is not a pie in the sky thing. You heard from the property owner herself telling you she was a nurse practitioner. She was caring for elderly parents, and they were asking for relief. In terms of demanding a medical letter from the opponents, I don't know what else you can say. We're not in the habit of getting up and misrepresenting the facts in front of this board or any other board. And I can tell you that, other neighbors tried to access the property and determine whether or not there was a drainage problem that was occurring. When we looked at the drainage patterns and FEMA maps, this area is not in a drainage or a flooding high risk area. It just simply isn't. The flows and the flooding that may occur are natural and have been, and they're historic. And it's not been adversely affected by 1508 Arawana. It is what it is. But we're telling you here tonight that in the post condition, we're going to improve that, and we're going to grade the area so that the water flows away from the north property line. So,
That's time.
just let me finish one more sentence. So, with respect to the pre and post condition, it's improved. And they should see a relief and a better position regarding drainage in the future as opposed to now. Thank you.
Okay, so we will now close the public hearing and open it up for motion or board discussion. That means somebody's gonna have to make one of those motions.
Yeah, so I'm not ready to make a motion yet, because I have one outstanding issue that I'd like to vet with the rest of the board. I feel that the drainage issue has been addressed, not really, in my opinion, on the table. The issue with the encroachment from the other property, also not really our issue. The only issue I see is whether there is a hardship for the pool itself. The hardship, if a pool is permissible, and it is, it's just a question of how far it has to go from the house and up to the neighboring property. It seems clear that there is sworn testimony upon which we can rely that an ADA requirement exists to at least create a buffer between the property, the existing structure of the property and the pool. But the issue that continues to frustrate me is, does the pool, is there a hardship itself for the pool and to push it up to those 3 feet, and the width of the pool was never really addressed. And so that's the issue I'm trying to wrestle with, and that's the issue I have, I'll present to the rest of the board for discussion.
So I recall that there was a discussion a couple months ago when we first heard this case about the width of the pool, and for some reason it needs to be the 10 feet wide. I remember us discussing that, and that for some reason the petitioners could not make the pool more narrow. I agree with Mr. Feldman that the issue is whether or not these particular applicants have a hardship in constructing a pool. And what's interesting to me, and I think in normal times, this board could very reliably and be justified in determining that the applicants don't need to construct a pool. However, in light of the fact that there's a pandemic, I think the applicants made a decent point that, you know, bringing an elderly mother or grandmother to the YMCA or a community pool just isn't, I don't think it's realistic for us to demand that the applicants do that right now. So then I guess the issue becomes, well, can they, you know, do some other sort of exercise at home maybe to get the same benefits? But like Mr. Feldman said, I think that we can rely on the testimony that was presented that a pool is necessary for therapeutic reasons. So those are sort of my thoughts, but I agree that the sort of outstanding issue is whether or not the pool itself is the hardship.
I have the same questions you have. I'd just make the comment that the decision we make rides with the land forever. So, you know, to base it on a temporary condition needs to be considered.
So that's why I was concerned with the issue of the legal issue of whether an ADA compliance. I mean, I'm actually looking for some of the training that we did to see if there's something that we can rely upon regarding ADA. I recall ADA being a legal issue that permits a hardship. But, you know, certainly we've heard testimony tonight that from the therapeutic standpoint, you know, a pool is necessary. And you're right, I do recall hearing some testimony once before about the width of the pool, but it was never really clear to me what the basis was for that. So.
Lynn Hertak, I'm also kind of curious, and it didn't dawn on me until he had the new layout there for us, that I don't know why the pool has to be in front of the doors, where it could possibly be moved out of the way of the doors. If you look at the plan, I mean, so I'm agreeing with you on that, with the width of the pool and why it is where it is. It could be put somewhere else on the lot. Yeah.
So would anybody like to make a motion?
I'll make it easy on everyone. Motion to approve. Am I looking for a final approval without condition?
If that's
Yes,
the
ma'am.
motion, if you don't want to attach conditions to it, then that's the motion language that you would use.
Would anyone like to attach any language to this? I'm going to give it a straight approval. The gentleman said that he would warrant that there would be no screen cage around it to further encroach on anything that the neighbors have. Otherwise, I'll go for straight approval.
Kamaria Pettis-Mackel from the City Attorney's Office. If you're asking to put a condition, you could simply put a condition on. I don't want.
I wouldn't have put a condition on, but
Okay.
the homeowner did mention there was a condition that he was willing to do that evidently might satisfy some of the concern that the adjacent property owner might have in regard to a pool cage. So I can include that in and the language of the proposal also will be approved. Okay, so approval with conditions. I move that the variance request for case VRB 20-60 located at 1508 South Arawana Avenue, as depicted on the site plan, presented at the public hearing for a variance to reduce the rear yard setback from 5 foot to 3 feet, be granted with the following conditions: that the homeowner warrants that there will be no pool cage assembled once the pool has been installed, and that the said variance as conditioned be granted based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 criteria set forth in section 7280 of the city code.
Excuse me, it's 2070.
Excuse me, 2780, excuse me, my bad eyes. Specifically that the applicant has produced sufficient evidence that that a hardship does exist.
Could you state the hardships, please, for the record? In
That the
motion?
hardships do relate, in fact, to ADA considerations to make the house more accessible for a multi-generational living situation.
And I would add, I would second it if you were okay with a modification, stating also that there are practical difficulties with the existing structures on the property, creating space for wheelchair accessibility between the structure and the pool.
I accept that.
All right, then I'll second it.
Okay, can we have a vote, Ms. Long?
I have a question.
Okay.
Do you have a question, Kamaria? It's not from the city attorney's office. Do you have a question regarding the motion?
Usually we make a motion and then we discuss it.
Can discuss it, and then we vote on it, but we were never given an opportunity to discuss that. Okay. Did the applicant ever agree to never enclose the
Yes.
pool?
Yeah,
Oh,
that,
I missed that, okay.
so, but while the motion has been made and it's been already seconded, Mr. McLean, can you, on the record, acknowledge the condition that was placed on the motion and whether or not you accept that motion? I mean,
Yeah,
the
yes,
condition-
we accept the condition. That the pool will not have an enclosure in the future, this is a request for the
Okay.
pool and the distances as shown on the site plan, and does not include any enclosure.
Okay. Aye.
Dustin Pastor, nay.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, nay.
David Farrell, aye.
Motion's approved 4-2.
Thank you so much, Board, and certainly under these new conditions, it's quite an experience, but I appreciate your indulgence.
Okay, the next case is VRB 2103. Have they already been brought up? Looks like no.
Yeah, I just want to give them a second to step out and then
Okay.
everyone come in. They're gonna swear you, he's gonna swear you in and then we'll get started, okay? It's okay, you can turn around. The board is right here.
Okay.
Thank you.
He's right, this is, you're the board right there. Can you go ahead and swear them in?
Okay, case 2103 at 5099 East Washington Avenue. Is that you guys?
Yes.
Yes? Okay. Mr. Sousa, could you please tell us
Wait.
about this case?
Please, for the swear-in, please raise your right hand. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And you guys can have a seat right here.
Thank you, bro.
Okay, Mr. Sousa.
Yes, sir. VRB 2103, property address is 5099 East Washington Avenue. Property is zoned CI, commercial intensive. Property owner is the Egypt Temple Shrine Holding Corporation. Agent is James Ullery. They're requesting building sign square footage from 350 square feet to 518.16 square feet of building signage, and to allow a freestanding sign with electric center along a local street. And the proposed work is to install 2 building signs and 1 freestanding sign on the property to allow an increase of building signs from 350 to 518.16 square feet. DRC has reviewed this application and finds it consistent. No issues. Let me show you where this property is. Am I up? Yes, I am. Okay. This is the property. It's a brand new building under new construction. This is East Washington Avenue. It's roughly, it's southwest of Adamo Drive and US 41. And it's right here along a canal that the city owns. This is the portion of the building that's being finished up. This is an aerial of the building and the property. This is the site plan that's been provided to you. The sign is going right, the freestanding sign is proposed here. They're putting one sign, 191 square foot sign here, and the larger sign on the back here. This is the proposed freestanding sign that's going to be up along Washington Street. Unfortunately, the road that is currently in front of this particular development is a local street. The code does not allow freestanding signs along local streets. So, that being said, the zoning administrator is allowing the VRB to make that determination of whether the freestanding sign can exist and in its form that's being presented to you. This particular sign is 129 square feet in size. You take it from the top of the electronic message center sign down to the bottom of the cap. And it also has a 38 square foot message center sign component to it. So you're going to be making a decision on this, whether it can exist in this form or not. This is the 91 square foot sign that's going on the front of the building. Let me take you back to the site plan, just to let you know. This is where the 91 square foot sign's going, facing Washington. Based on the conversation with the zoning administrator and staff, the water counts as an accessible right-of-way. So technically, they have 2 building frontages, one here and one here. So they are putting the 91 square foot sign, this one, on the front. This one right here. And this one on the back. This one's showing roughly 426 square feet. So if you put them all together, you get 518, I believe, 0.14 square feet of building sign. So they're asking the larger of the signs to go on the back of the property facing the canal. And that is what's before you this evening. If you have any questions, staff's here.
Thank you, Mr. Souza. Applicant, please step forward. State your name.
That's up to you.
Thank you.
Please state your name, address, and if you've been sworn, please.
My name is James M. Ullery. My address is 2170 Sunnydale Boulevard, Suite U, Clearwater, Florida. And I am the authorized representative of the Egypt Shriners Holding Company, and I am here tonight to discuss our project known
Excuse me,
as
sir.
VRB.
Have you been sworn
21.
in? Have you
Please.
been sworn in?
Yes, we are been sworn in, sir.
Okay. You've got 10 minutes to present.
Thank you.
Okay.
Okay. My name is James Ollery, as I just said. I am the president of LEG Tampa. We are the authorized representative of Egypt Shriners Holding Corporation, who has just completed a brand-new facility that is located, the mailing address at 5017 East Washington Street. The facility has 25,000 square feet, including office support for the Egypt Shriners, meeting place, community rooms, banquet facilities, and the Oasis Lounge. As Joel pointed out to us, East Washington Street is considered a local road, and thus the amount of signage allowed for building and freestanding signs is limited. We took into consideration the existing code and also the needs of the community as to how to properly identify the new facility. We have designed building signage to identify the building to those that travel on East Washington Street. We will consider this the north elevation or the front of the building. We have also designed building signage to identify the building to those who travel on the traffic way on the south elevation, also known as the back of the building. Most of this traffic would be those traveling on 50th Street, traveling in a northbound direction. We will consider this the south elevation. We would like to speak briefly about the existing sign code for this property on a local road. The City of Tampa sign code, as we interpret it, allows for only one wall or building sign with a maximum of 197.5 square feet. So that would be applied to the entire facility, both front and back. Considering the size of the facility, we have designed signage utilizing channel letters on the north and south elevations. Channel letters are architecturally pleasing and have a classic look and a nice appearance. The total square footage of our requested wall building signage for both front and back is 518.16 square feet. We are requesting a variance which will provide an additional 320 square feet of wall building signage and to have signage on both north and south elevations. The City of Tampa sign code does not allow for an electronic message display or freestanding pylon sign facing a local roadway. The new facility is a multi-use facility which includes banquets, weddings, community meetings, and functions for the membership of Egypt Shriners. We are asking for a variance to allow the installation of an electronic message pylon display facing East Washington Street. This will provide the facility with the ability to display public information and announcements regarding the functions taking place at the Egypt Shriners facility. Egypt Shriners have made a substantial investment in this new facility. Our mission is to provide well-designed signage so the facility is an attribute to the local community and to the City of Tampa, Florida. At this time, I would like to introduce James W. Litch from Egypt Shriners, who has a few additional comments.
Please also state your name, address, and whether you've been sworn. Thank you.
Thank you, Jim. Good evening, members of the Variance Review Board. My name is James Litch. I live at 116th Avenue Northeast in St. Petersburg, Florida, 33704. And I stand in front of you to support what we would like to have. Our primary goal with building the building was to bring a new structure to the community, an opportunity for people to come, have a place to meet, have a place to come together, and more importantly, for us to raise revenue and funds for our children in our Shriners Hospital on the USF campus. So I just stand up here in front of you to thank you for the consideration. We look forward to hopefully an approval. And again, thank you very much.
And could you just confirm you were sworn in, please?
Oh, yes, indeed.
Okay.
I was sworn in.
Thank you. You guys still have 5 minutes left if you need it. If not, you can, conclude. It's your choice.
We conclude.
All right, thank
Thank you.
you. Is there anybody in the audience that wishes to speak on this case? Seeing none, then we'll open it up for board questions. That's all you guys.
Takes me a minute, man. Takes me a minute to process everything that's being said. All right, just, I understand the building signage. You have a very large building. Putting some signage up there to identify it makes sense. I understand the nature of a freestanding sign. What else is around? Can you tell me what else is around there in terms of the neighborhood? Looks from the limited information we have, it doesn't look like there's much around you guys.
Yes, sir. On East Washington Street itself, there is a radio station that's maybe a half a mile down the road. Adjacent to our new facility, which faces 50th Street, there is a mobile gasoline station that has a Dunkin' Donut shop attached to it. And other than that, there is no other active facilities right near the building. As you go a little further down 50th Street, there are some other facilities. But for the most part, that is the extent of what is next to us.
And Mr. Sousa, you said that this was commercial intensive zone?
Yes, sir.
Is the whole area across the street, is that also commercial intensive?
Based on our zoning maps, you have RM24 and CI, a bunch of mixed zoning districts within this area.
All right, that's all I have. Thank you.
And on the same line of questioning, directly across the street to the north, it looks like, from what I can see on Joel's screen there, there's some sort of a racetrack design or something. It's mostly trees. Do you guys know what that is?
Yeah, please do, James.
Okay, great question. So I've been involved with the project since we started in 2014 over at 4050 Dana Shores and moved back into the city of Tampa. The racetrack, in fact, that's what I thought it was originally too. It's actually a drainage. So coming off the Leroy Selman, it drains right off of there. Oil, gas, tar, everything goes right into this holding lake that looks like a racetrack, but that's water actually.
Yeah.
And then when it floods or anything, it washes over that and spills into the wetlands and goes into the river.
Okay.
So there's no structure there that's owned by Florida Department of Transportation or somebody.
Yep.
Then there's an empty lot that's a commercial intensive, and then next to that, going west on the north side of Washington Street, is another piece of property, which is really the on-ramp to get on the Leroy Selman, and that is owned by Florida Department of Transportation as well.
Right. So obviously the reason for our questioning is the people most impacted by an electronic sign are the people across from the sign.
Mhm.
It looks like in this case it's commercial use in the future. Right now it's vacant, and or FDOT drainage. So that's why we were asking.
Okay. Thank you.
Are there any other board questions?
I have a question.
Okay. Sloan?
Could you put up the overhead picture of the property for me to look at again?
Yes, ma'am.
They'll put it up. They have it. We don't have.
Joel, do you want me to put one down, or can you do it?
I did, you could put, there's a.
Right here on this thing?
Okay. I'm sorry. Let's put this one up there, James.
Cool. Is that sufficient?
Is that sufficient, ma'am?
Okay, now can you put your finger where the freestanding sign is gonna be?
Right there.
With the LED in the middle of it? It's gonna go there?
Right
Okay,
there where my top, above my finger, right there.
okay. and then you're gonna have one on the face of the building, on the front of the building,
Right here,
and one on the back of the building, which is facing the canal.
correct.
Why did you want it on the canal? You told me, but I missed.
Yes, as traffic on 50th Street is traveling northbound, they see the building, but they have no idea what is in that building. So the signage on the back of the building will help identify the facility to those on 50th Street traveling in the northbound direction.
Okay, now I understand. Thank you.
You're welcome.
Okay, any other board questions? Seeing none, you guys have 3 minutes for rebuttal if you need it.
I don't think we need anything else.
We do not need any time for rebuttal, sir.
Okay, thank you. Then we will close the public hearing and open it for a motion or board discussion, please.
If no one has any objection, I'll go ahead and make a motion. I will move that the variance request for case VRB 21-03 for property located at 5099 East Washington Avenue be granted as depicted on the site plan presented at the public hearing to allow an additional building assigned square footage from 350 square feet to 518.16 square feet of building signage with 91.83 square foot sign, freestanding sign, with 91.83 square foot sign on the north elevation and 426.31 square feet on the south elevation, and to allow a freestanding sign with an LED electronic message center along the local street right of way pursuant to 27-289.4. Based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, as well as 27-289 as discussed earlier, specifically that this is an extremely large structure in a commercial intensive, relatively low, wide open, no other structures around it, with what appears to be FDOT and additional commercial intensive across the street, such that the LED signage will have little impact, and the large signs on the structure are necessary to identify the structure.
Second. David Farrell.
Second, Mr. Farrell. And the vote, please.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, aye.
David Farrell, aye.
Motion's been approved 6-0.
We thank
Thank you very much.
Thank the review
We
board.
look forward to having you and your events in our new facility.
Please stand and raise your right hand. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
Can you guys have a seat in the audience?
Good evening.
Okay, so case VRB 2116 located at 2906 West Akia Street. Is that you guys? Okay. Mr. Sousa, please tell us about this case.
Yes, sir.
Hold on 1 second.
Thank you. It's there, okay. Okay, property is zoned RS50, residential, single family. Property owner is Christopher and Sarah Redstone. Agent is Raymond Kleitz. And what we're doing is they're requesting to reduce a side yard setback from 7 feet to 2 feet to construct a new single-family home. The ERC has reviewed the request and finds it consistent with their requirements. Let me show you where it is. This is the zoning map that's in your packet. This is the RS50 zoning district. McDill is off to the west, right over here. Howard Avenue is to the east. This is Aquila and San Marti, and this is the property right here. Let's get right. This is the new and improved site plan that they provided for us. It's in your packet. This is the property site plan that they're proposing to build. This canopy with a carport is the request for the encroachment from 7 to 2 feet right here. These are the other plans that were provided in your packet regarding this project. This is basically what the lot looks like now. There's a large tree in the back, but it's a vacant parcel right now. And these are the renderings of the new structure with the carport that's been provided in the packet by the applicant. This is it right here. If you all see, you have two objections to the proposal that's provided in your packet. Disregard the last one, that should not be there. But you do have two people here that oppose the project.
Mr. Sousa, can you put on the record who the letters are from, please? And Kamaria Pettis-Malco from the City Attorney's Office. Thank you.
Okay.
And also their address, if they note it, please.
Nick Crone, 101 East Kennedy Street, Suite 2250, Tampa, Florida, 33602. We have Jim Hesberger, 2902 West Akia Street, Tampa, Florida, 33629. If you have questions, staff is here.
Okay, applicant, please state your name, address, and if you've been sworn.
My name is Daniel Correa. My address, I reside on 203 South Hill Avenue, Tampa, Florida, 33609. I have been sworn.
Okay, you have 10 minutes to present.
Thank you. Good evening, board members. My name is Daniel Correa, and I am the architect who has been working with Chris and Sarah Redstone on their forever dream home for the past few months. When approached with the possibility of designing a project for this site, I was happily surprised to listen to the vision that Chris and Sarah had for their home. They did not want the home to be overbuilt for the size of the lot. They did not want to have all the features that attract so many. They wanted to have all the features that attract so many of us to South Tampa. The goal was to eliminate a large garage door so that the front facade would be characterized by a large front porch, which was from the beginning. It was a directive, and I was very happily challenged, as I knew that this would be a very good project for our company. It also meant that we would have to push the garage as a detached structure in the rear, and there's a sacrifice on their side where the backyard real estate would have to be sacrificed for that matter. Throughout the design, we focus on our efforts on bringing the scale of the building down to a human scale. By not having a two-story wall closest to the street, the building greets you with a much more friendly scaled-down volume. Taking inspiration from existing homes in the neighborhood, we looked at existing case studies we found around this property to shape the proposed buildings so that it would blend with its surroundings. Below, I'm about to mention a few addresses, a list of residences that are grandfathered in the land development code that would also drive our point regarding this hardship, which is not self-inflicted, but that leave Chris and Sarah without the possibility to build and recreate their home to mimic the charm and functionality of carports that were designed with the goal to protect residents from the weather temporarily and to hide the car in the rear of the property so that the facade would be celebrated. The addresses that have the same feature are 3800 West Aquila, 2806 West Estrella, 2903 West Estrella, 2810 West Estrella, 2911 West Estrella. There's a few more, but these are within 2 blocks of the residence. So we also focus on setting back the carport so that the volume closest to the street happens to be the front porch with all the architectural elements that characterize charming single-family residences surrounding the property and subject. Gable end roof with architectural brackets, wide-based tapered columns. We, of course, eliminate single and double door garage from the front facade. And the 2 elements that encroach into the side setback are the 2 columns that are not a solid wall. This is also architecturally consistent with the historic nature of the carports. And at the human scale, with a tall carport, it allows the passerbys to extend their view all the way to the rear of the residence. So it's not a massive structure that happens to be sitting 2 feet away from your neighbor. It's just 2 columns with a carport. I believe that the nature of this request is reasonable and will not interfere with the health, welfare, and safety of others. We believe that the hardship Chris and Sarah are experiencing resides in their inability to recreate the original intent of the Land Development Code, which has changed over the years to accommodate rapid growth and large density. This home will not set a trend for the future development. It will continue and enhance what is already created over many years. Thank you, and we kindly request that you consider granting us this variance. I have, I can pull out in here. So anyone here to see? The house, the property is subject. So on the left, we'll see this is MacDill. This is the property in subject. Just in front of us, we have a condition that meets that criteria. Now, the difference is that that's a full, almost fully enclosed carport. What we are proposing is a much less intrusive. It's just 2 columns, no walls, tall carport, and we're sensitive to our neighbor. We don't want to bring a full structure, a full wall to that side of the neighbor. And there's a few other residents in here that I don't want to struggle in front of live audiences, but there's a few other ones which are listed in that written statement. 3800 West Aquila. West Estrella. This one also happens to be, grandfathered in. It has a similar condition where the carport extends over the setback. And like that, there's about 7 of those around that 2-block radius.
Does that conclude your presentation?
Yes.
Okay, thank you. Is there anybody in the audience that wishes to speak on this case? Please state your name, address, and if you've been sworn, please.
Name is Chris Redstone. Address is 5145 Southdale Mabry, and yes, I've been sworn.
Oh, are you the petitioner?
I'm sorry?
You're the petitioner?
Yes.
Oh, okay, well, you
Should I
still
just
have
say that?
time, so you can continue.
Okay. Yeah, I had prepared a letter. I just wanted to read to you all. Greetings, Variance Board review members. We're Sarah and Chris Redstone, and we would like to build our home at 2906 West Aquila to match the historical look of the Palmacia area. I'm a native Floridian. Sarah and I moved here in the late 90s. We lived in Palmacia for about 5 or 6 years, right next to that dog park, if you're familiar with the area. We fell in love with the area. We fell in love with the streets, the shadiness. It's a really great place to live, and that's why we wanted to build our home there. We've actually looked for a lot in that area for 8 years or so, something like that, and this finally came up, and we were so excited to get it. While our home will be new construction, we aim to build our home in a similar bungalow architectural style. Part of that style is the carport. As you can see in the supplied pictures that we had, it's really common in the area, and we believe that adding another bungalow home to the neighborhood will help further enhance the character of the area. While we're asking for the change in the setback to support adding the carport, a driveway would occupy that area anyway, without the roof covering. We also agree that trying to maintain as much history on the property that is feasibly possible. When we purchased the lot, the previous homeowner requested that we try to keep the mango tree. It was really special to her, and that touched us as well, right? There was a certain sense of history to that lot. There was a certain sense of history that was important to her, and that's important to us as well. That's why we want to build a bungalow-style home. One other thing, trees and vegetation are super important to us as well. Sarah's an avid gardener, and we really want to maintain that look in the area. Anyway, thank you for your time this evening. We do hope that the committee grants us this change in easement so that we can build our dream bungalow that will live in for many, many years to come. Thank you.
Okay. Thank you. Does that conclude your presentation?
It does, thanks.
Okay. Now, is there anybody in the audience that wishes to speak on this case? Seeing none, let's open it up for board questions.
I'm sorry, as the builder on the committee and having 9 years sitting on the ARC, everything that they presented this evening is correct. And
We're not supposed to do our own testimony, Mr.
Yeah.
Farrell.
Good question.
Yeah.
We're just
Oh,
supposed
no,
to ask
ma'am, excuse me,
questions.
okay, all right, yes, sir, all right, we can't discuss that. My point is that bungalow style is,
No, do you have a question?
oh, do I have a question?
Right.
Do you have a question for them?
Oh, no, I thought we were discussing.
No,
Excuse
no.
me, I'm sorry.
We're open for
We'll get
questions.
there.
Nope.
Does anybody have a question for
Yeah.
them?
I do.
Mr. Feldman?
Let's
Mr.
start with
Long.
Ms. Long.
Go ahead.
Susan Long, where'd they go? This is for the petitioner. Well, either one can answer this question. Okay. Susan Long, am I correct in looking at the floor plan? This is a 1-bedroom, 2-bath house?
I
1
believe,
bedroom upstairs, and
no,
No,
so
it's
there's more upstairs?
yes.
yes,
Okay, so that was just the way, the drawings that we got, because I was going, this is
Yeah,
kind of
could
a
you
big
just show
house
us
for
the floor plan?
one
yeah,
bedroom.
absolutely. So on the first floor,
Yeah, I looked at that, no problem.
yeah, we have an office,
Yeah.
and then we have, actually, this is supposed to be, a bedroom, a guest bedroom on the first level, and then we have a master bedroom, and then
Mhm.
we have, again,
Can you
we're,
zoom it out a little?
Can
yes,
you move it
We
up?
can't see
sorry,
what
I'm
you're
sorry.
saying.
There you go.
sorry.
Okay, so there's
So it's really not a lot of density.
1
what we're
bedroom.
bringing.
What's the total square footage?
I knew you were asking that, and I will have that in here. Okay, so roughly, total living is 1988.
Okay.
Yep.
That's all the questions I have. Anybody else have a question?
Yeah, Brett Feldman, just a quick question. What you're proposing is an open carport that is coming pretty close to the setback, and you made a fine point that the driveway would be there anyway. Is this, would you accept a condition that this carport never be enclosed? Should we approve this?
Yes. Oh,
I mean, I thought as much, that's the design of it, but logically, we have to ask that question.
Right.
Okay, thank you.
I have a couple questions. The first one is, I saw that there was a grand tree on the survey. Are you guys keeping that?
We are working with Ricky Federica. He's a arborist, and I think he's out of the board for many years, and he did an arborist report on it. I believe the condition of the tree is hazardous, and it will be removed. There's one tree that was going to be removed, correct?
yeah.
Kamaria Pettis-Mackel from the City Attorney's Office. There is a representative from Natural Resources if you have questions from Natural Resources.
Okay, I didn't see the tree on the survey, on the site plan, so I just,
Right.
didn't know if you guys had reconfigured the house to try to save it or something, but, okay.
We are removing it. It is a hazardous tree.
But you're keeping the mango tree?
Really want to. Really want to.
And Kamaria Pettis-Mackel from the Legal Department, since this is a quasi-judicial hearing, can you please come to the microphone to speak
Oh, I'm
so it could be recorded? Thank you.
absolutely. Apologize for that. Yes, absolutely want to keep the mango tree.
Okay. And then how wide is this lot? So it's zoned RS50, is it 50 feet wide?
Yes.
Yes.
Okay. Okay. So, yep, I guess that's all the questions I have.
there any more board questions? Seeing none, you guys have 3 minutes for rebuttal? No rebuttal? Okay, then we will close the public hearing and open it for a motion or board discussion.
Thank you.
I'm okay with making a motion if everyone else is. All right. I move that the variance request for case VRB 21-16, located at 2906 West Aquila Street, as depicted on the site plan presented at the public hearing, to reduce the side setback from 7 feet to 2 feet with an encroachment of eaves and gutters, with the condition that the carport never be enclosed, that said variance as conditioned be granted based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code. Specifically, that the applicant is presenting a very reasonably sized home, that the setback encroachment is only for an open carport, that it has been demonstrated that it is consistent with the neighborhood pattern, and that a driveway would exist in this location anyway. Therefore, the only thing that's encroaching is 2 posts and a bit of a roof. That's it.
Second, David Farrell.
Thank you, Mr. Farrell. And a vote.
No, I'm sorry, Kamaria Pettis-Mackle from the City Attorney's Office. Before the members vote, can the applicant or the agent please come back up to the podium to acknowledge the conditions that were placed on the application?
Yes, I acknowledge the condition.
Okay.
Are we
Ms.
ready?
Long.
Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, nay.
Lynn Hurtak, aye.
David Farrell, aye.
Okay, your motion's been approved 5-1.
Thank you very much.
Excuse me, Mr. Chair, may I approach really quick? Do you need to take a brief recess in order to do that?
It's gonna be quick.
Do you want to recess or?
No, we can do it.
Maybe we can do the swearing in while Joel is transferring the thumb drive.
Can you do the swearing to the,
Anyone who is speaking or giving testimony or might give testimony, can you please stand and raise your right hand? Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
2119, located at 119 Biscayne Avenue. Mr. Sousa, please tell us about this case.
Sure. Joe Sousa, Development Coordination. Property is zoned RS60, residential single family. Property owner is Andrew and Shannon Goolish, and the agent is the same. They're requesting an increase in height of an accessory structure from 15 feet to 27 feet. To build a new accessory structure for living areas, screen patio and bathroom and pool house use. Again, DRC has reviewed it and has no issues with the request. Let me show you where this is. This is the front of the house. I'm waiting. Sorry. It's okay.
Multifunction tonight.
Thank you, thank you. Let me see if I can get a nice close for you. This is location, this is over on Davis Island. This is the property address on Biscayne Avenue. The commercial area of East Davis is over here. Here's West Davis. It's kind of in between them both. Sorry. Each picture is a little different. This is the front of the house. And this is the site plan that's in your record. Everything's staying the same. What's being proposed is this casita in the back. A large area of it is enclosed porch area. They're allowed up to 900 square feet without having to meet main structure setbacks. They're proposing 872. So all they need is the height from 15 feet to 27. This is the elevation drawing. What you see in black is the screened-in porch that wraps around. Because they're in a FEMA flood, they're having to increase the finished floor height, as you can see right here. And you do have an opposition letter from the Davis Island Civic Association. Janice Davis, do I need to give her address? And this is in your packet. Staff here is here if you have any further questions on this matter.
Maria Pettis-Knuckle from the City Attorney's Office. Mr. Sousa, can you clarify that they're asking for the applicant is asking for a screened porch? I think you had mentioned enclosed porch.
Well, it's a screened porch here.
Okay.
Okay, applicant, please come forward.
Okay. Yeah, you can go ahead and bring it up.
State your name, address, and if you've been sworn, please.
Andrew Goolish, 119 Biscayne Avenue, Tampa, Florida, 33606, and I have been sworn in.
Okay, you've got 10 minutes to present.
All right. Good evening. Thank you for the opportunity to present this case to you tonight. As Mr. Sousa detailed, we are asking for a variance to the height requirement for an accessory structure from 15 to 27 feet. And a portion of that request is due to the FEMA flood zone requirements that when I submitted this application in October, the FEMA flood elevation was 10 feet above sea level. And the time between October and now, that has now been increased to 11 feet. City of Tampa building requires that we also have an additional 1 foot of freeboard. So what that means is that with the 15 feet building height requirement being based from the existing ground elevation, for the old requirement, 4.2 feet of that is already eaten up with the flood elevation. And the reason to bring that above is to have plumbing and electrical on the first floor of the pool house.
So at that point, given the opportunity to build on what is green space and kind of a unused portion of the lot, we look to maximize the other opportunity for 900 square feet and go to the second story. So in reality, with the first now 5 feet being taken up with the flood requirements, the requirement is really only, or the ask is really only for 7 additional feet of height. As presented in your packet, this is a aerial. You can see that we are on Davis Island, about in the middle, but we're still required to meet the same flood zone requirements as a majority of the island. Just to give some context, you saw the front elevation of our existing home, which is built at grade level, was built in the 50s, and has pretty much existed since then unchanged. So you can see to the rear of our property, there is a 2-story or almost 2-story structure, being the pool enclosure for our neighbor to the rear. You know, we feel that the structure we're proposing at the rear of our property would both provide us and our neighbor to the rear additional privacy. As you can see on the elevations, I've limited the amount of windows, as well as made them transom windows that are higher than, the sill elevation is higher than what is typical for windows. Well, go back real quick. And as you can see, we have new construction to the east of us, which is raised above to meet that new requirement of 12 feet. So you can kind of get a visual as to what that really means for our property. And then to the west is another existing structure built in 2008, which is a little bit lower because the existing codes weren't in place at the time. The proposed site plan is here, similar to what's in your packet. We're meeting the other accessory setback requirements of only 3 feet for the side and rear, and that actually increases as the lot line moves to the northeast. We're also bumping up against the total impervious with this proposed plan, which is 50% without additional considerations for drainage on site. So we're working on several different items to make this work. As you can see, this is the elevations that are in your packet, same as that. And then, again, just wanted to point out the rear elevations. Majority of it is, you could term it, I guess, a privacy wall from some respect, but does provide some light. The floor plan, again. So this is just a restating of what was submitted in the packet, the original base flood elevation, and then the design finished floor elevation. On this one, I just wanted to highlight that it was 10 feet for the flood elevation, 11 for the design flood, and now those both have increased by 1 foot. To the other statement of hardship or tests, we haven't modified the property at the time of purchase. We don't believe this will negatively impact the health and safety of neighboring properties. And I'll state that there are several other properties on Davis Islands that have 2-story accessory structures constructed prior to the current design flood elevations. And I've listed several examples there, but I've also included several other examples as you make your way around the islands. So this is actually just 1 street removed from us, about 1 block away. There's several, it looks like 2 accessory structures, one being 2-story. This one is right across the street from that one. Again, being a 2-story structure, and the time it was built, the base flood elevation was not established, so no consideration was made for the first 4 to 5 feet of raising the building. This one's a little harder to see, but it's in the back of a larger property as well, close to the property line. This one, again, a 2-story accessory structure. another. And this one's positioned more towards the rear of the property, similar to a couple slides ago. This one as well is on South Davis. Again, the side setback is fairly minimal, but obviously meets the requirements of accessory structures. At this point, just appreciate your consideration for everything I've presented and welcome any comment you may have.
Does that conclude your presentation?
All right? Yes, that'll conclude the presentation.
Okay. Is there anybody in the audience that wishes to speak on this case? Please come forward.
Chairman, staff is in receipt of an objection, would like to pass it to you for review.
Okay.
If you could just put who the objection is from.
Can I take this off?
We could hear you through the mask.
Okay.
We can hear you through the mask.
Okay.
Hi, my name is Mike Helton.
Hold on one second, sir.
Wait, please.
Thanks, Joe.
And Mr. Sousa, if you could just put on the record who the letter was received, who the letter is.
Letter was from
No.
Debbie. Joel Souza, Land Development. You just received an email message from Deborah Zalmerman.
Okay. Thank you. All right. Please state your name, address, and if you've been sworn, please.
My name is Mike Helton, and I reside at 117 Biscayne, which is directly next door to the property that we are discussing.
And have you been sworn in?
Yes, I was.
Okay, you've got 3 minutes.
I won't need 3 minutes. I'm basically here just to ask you to approve the variance. There's no one on the DI Civic Association or anyone in this room that lives any closer to this proposed structure than I do, except the residents themselves. I have no problem with it whatsoever. You probably saw my house being built there. We had an older home as well, tore it down and in the process of building. We plan on staying there for quite a long time. My wife and children, and we have no problem with this variance at all. I just want to put that on the record. Thank you.
Thank you. Is there anybody else that wishes to speak on this case? Seeing none, let's open it up for board questions. I have a question. We're going to need an applicant up here to answer it, though. Have you spoken with your neighbor immediately to the rear
I have not.
at all?
No, sir.
And you haven't heard anything from them either?
No, sir.
Okay. Other questions?
Lynn Hertek, I have a question for you. How high are the ceilings in both the first and second story?
Do you mind pulling that?
The applicant would like to go back to the PowerPoint presentation. There it
Yes.
is.
Thank you. Let's see. That's right there. So let's see. 11. I believe I've allowed for about 9 feet in both stories. So minimum being typically 8 feet. The structure isn't so large that necessarily requires 10 feet ceilings that are typical these days. So between the 9 feet of each, you're at 18 right there. Losing 4 to 5 feet at the ground level is 13. With some structure, say 1.5 feet, that's 23, 24 and a half, and then with some roof structure as well.
Thank you.
So we received, an objection from the Davis Island Owners Association and, from DZ Home, and both of them address, the gross floor area, so it's legal. Does a screened porch count for gross floor area?
Kamaria Pettis-Malco from the legal department. Staff has reviewed the application and do not find, staff has determined, and Joel, Mr. Sousa, you could address that.
Yes, Joel Souza, Land Development. I've spoken with the zoning administrator about this. With regard to accessory structures, we don't count screen rooms and similar patio areas as part of the accessory structure itself.
Lynn Hertak, one more question. Would you be okay with a condition put on that that would never be enclosed?
Sure.
Okay, thank you.
Okay, so I've got one more question for the applicant. You know, gotta admit, I didn't 100% follow the FEMA, flood requirements, but what I did gather was that basically you have to raise your house by 4.2 feet to comply with the current FEMA flood standards.
Correct.
But you're asking for a variance of 12 feet.
Correct.
So can you help me understand the extra kind of 12, like, I completely understand request to increase the structure by 4.2 feet, but you talked a lot about how, some other neighbors have two-story structures, but presumably they complied with the requirements in effect at the time. So can you just talk a little bit about, the hardship for that extra area?
Sure. Most of the structures that were shown were historical structures before any type of base flood elevations were established by FEMA. And so when they were built, they were not required to raise the bottom floor elevation to comply with building codes. So, the historical precedent that I'm trying to present is that on Davis Islands, there's been some historical precedent for having a two-story accessory structure, which are over and above the 15 feet. So therefore, the base flood elevation is requiring the elevation of the current structure. And at the same time, I'd like to, be able to build a two-story structure at that new baseline elevation, if you will, similar to those as before.
My question is for staff. I do not know who is best suited to address this question, so I'll ask it and let you folks sort it out. Has the city of Tampa, we talked about this at some petition some time ago, but has the city of Tampa yet addressed how it's interpreting the height limitations with FEMA requirements? Have they adjusted at all for newer FEMA floods or anything along those lines?
Joel Souza, Land Development. No, zoning requires us to go from average finished grade, regardless of the FEMA flood requirements.
And Kamaria Pettis-Malco from the city attorney's office, there is direction with city council to address the definition of height, but that is not, that's still before city council, so that provision has not been changed yet in the code.
Okay.
Okay.
All right. So, but they are thinking about it, is what you're saying.
Yes.
Okay. This is a more general question. You said you go by average finished grade, Mr. Sousa. If they were to put, if the applicant in this instance, hypothetically, were to put 4.5 feet of dirt in the backyard and built off of that, would the height be measured from the dirt itself, or would it go from some different average that you're factoring?
Joel Sousa, Land Development, it would be prior to the dirt being put on the site. It's the average grade as it sits. You can't change grade without another process being involved.
Okay. All right.
Mr. Sousa, isn't the FEMA line based on sea level?
It is. Joel Souza Land Development, yes, that's true.
So mounds of dirt don't really affect that at all?
Yeah.
Not at all, and we're not allowed to interpret it as doing so. We have to go straight from a grade, as indicated on surveys.
So I think the question at hand here for me is the hardship related to the second story. I mean, a one-story that's 15 feet allowable, asking for 19 feet because of the 4 feet, is a different question than, you know, 2 stories asking for 27 feet. So I think really the only question at hand here is the hardship for the second story.
I mean, I guess to that point, I would say.
Are you asking a question, Mr. Chair?
Yes?
Okay.
So I guess to that point, I would say that given the existing home and the desire to include a pool into this construction and to maximize the available square footage, it's really to go vertical. You know, as Mr. Helton described, he's building a new home next door. You know, we have an existing home that was built in the 1950s, and so to keep that as it sits and be able to maximize the usage of our property within the code, except for one minor variance, that was the intent as far as the second story, was to be able to incorporate that pool as shown in the site plan, and that does meet all setback and area requirements for the property.
So the pool house is not required for the pool, but I understand that it supports the pool. The first story of the enclosed area is approximately 400 something square feet, minus a stair. So for any, you know, reasonable sized pool house, that's normally enough. Are you saying that both levels would be used as a pool house, or that they'd be used for livable space to supplement your existing house?
Both that as well as at-home office. My wife has a business that she works at from home, and so to provide some separate space for a home office, that would be utilized as well.
Okay. Are there any other board questions?
I have a quick question.
Okay.
On one of these, looking at the plan that shows just the overall, that also shows the houses in the back, the houses that abut this, it says there's an existing 2-story structure with an approximate location that's just catty corner. Is
Very
that
close,
is
yes.
that new development?
I believe
Or a new
that's
pool
within the
house?
past 20 years or so.
Okay. But is it a pool house or is it a main?
It's a garage with a storage space above.
Okay, thank you.
Okay, then you have 3 minutes for rebuttal.
Okay. I think I'm good.
Okay.
I appreciate it.
Then we will close the public hearing and open it for a motion or board discussion.
So I'm not making a motion. I'm going to just start the discussion. I have the same issue you raised, which is the concern over the second story and how the hardship was explained for that. I still believe that we should not be in a position of legislating the FEMA issue. I'm pleased to hear that City Council is addressing it, but I'd be willing to work within that, but for the fact that we've got this second story issue and an additional, call it 8-9 feet of height that I don't know that I can tie to a hardship. And if anyone else heard anything that addresses that, I'm all ears.
Well, I mean, obviously, I agree, I raised the question, but, you know, when you look at, they're allowed 900 square feet of accessory, which they're under, but only 15 feet, which implies that, you know, the intention is that that accessory is 1 story. Just due to the fact you can't really build an occupiable 2-story for 15 feet. As far as practical difficulty, we have looked at older homes before and had variance requests, whether approved or not, where we considered the livability of the space of the existing home and supplementing that elsewhere on the property. Whether or not that's a necessity or a hardship, you know, of the property is for us to determine. Practical difficulty probably is. We didn't hear a lot about the existing house, but we did see that it's a single-story older home. So that's all I got.
So, go ahead.
Lynn Hertek, I was gonna say something similar to Mr. Pastor. The residence on here, it says it's less than 1,500 square feet. So under, you know, adding and having an office space in a residence that small would be difficult, and they could tear it down and do what their neighbor did, but they're desiring to keep the original home.
And so here's the problem I have, all right? You're both right. You're absolutely right. It's a teeny tiny home. It's an existing structure. The pool is not existing. And that's the concern that I get, because the desire is to put the pool in, then put this item in, this accessory structure in there. And that is what creates, I mean, yes, it's a pool house, so there's no point in having a pool house if you don't have a pool. But if you take the pool out, you can build the additional living space. Frankly, you could tack it right on the back of the house and build all you wanted there, as long as you just, you know, meet structure setbacks. But so that's the issue I'm continuing to struggle with is, yeah, we've got it, but what's the hardship to say, okay, well, we'll allow it to go up the extra 9 feet when it's like, well, we're gonna construct this pool to go in there.
You know, what's also difficult about this is if we were to not approve it because of the second level, that doesn't give them a venue to build the first level, because FEMA's already pushed them out of that realm. So they'd essentially have to revise their case to even get approval on the first level.
Well,
That's the
I mean,
practical
we
hardship.
certainly have we have the right, if we wanted to approve up to a certain height, which has already been noticed.
Right.
We have that ability to do that now. I'm not saying that's what we should do.
Right,
I'm just
right.
saying that exists.
Yeah. Okay, any, Ms.
I listened to this, and everybody's concerned about the second story, but you know, if you drive around Davis Island, there are a lot of 2-story separated garages, whatever. And one of the things we're supposed to look at is it consistent with the neighborhood? In my mind, yes, it's consistent with the neighborhood. However, like you, he needs an office. You can't put one in a 1,400 square foot house. I have 1,800 square feet, and I have a little tiny office tucked in the back, and it's just me, you know. So I'm kind of inclined to approve it because, you know, the guy down the street, the guy across the street, the guy 3 blocks away, they've all got 2-story garages, casitas, whatever you want to call them. He called it a pool house, call it what you want. In here he calls it a casita, which to me was a mistake because that implies he's going to move somebody in. And that's what that word implies to me. Doesn't mean that's what he had in mind, but yeah. That's all I have to say.
Yeah, I mean, again, Ms. Long, I agree with you. I like to let people use their property. It's my desire to let people utilize their property, but we are constrained, in my mind, by hardships. And what I'm hoping I can hear, and what we asked questions about, what we didn't hear was the hardship for the additional 9 feet of height that's required, again, because put a pool in. And we've said this before, pools are great, they're wonderful things, but not everybody gets to have one if it doesn't work on the property. And so that's the issue that I'm struggling with. I would love to just say, yes, you can do it. The neighbor was gracious and said, you know, he doesn't have any opposition to it. It is, I agree with you, it is to some degree consistent with the neighborhood, although the neighborhood association is not real thrilled with the idea of it. But the hardship issue continues to give me pause. And if somebody has a way to get around it or address it, I'm happy to hear it.
Well, we're probably gonna have to make a motion at some point this evening. Is anybody inclined to do so?
Motion to approve with conditions.
Okay? Let's hear it.
I move that the request for variance case VRB 2119, located at 119 Biscayne Avenue, be granted as depicted on the site plan as presented at the public hearing for a variance to increase the height of the accessory structure from 15 to 27 feet. Hang on, I'm reading the wrong one. I'm saying with conditions, right? So, okay, specifically that, or the public hearing of okay. Let me start again. I was reading the approval without conditions.
Okay.
And then I got as far as, so is it the same? Yeah, so it's the same, okay. With the following conditions. That the height limitation be specifically restricted, be limited to 27 feet, and that the screened enclosure portion of the accessory structure never be enclosed. That said, variance as condition to be granted based upon the applicants presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria as set forth in section 2780 of the city code, specifically that the petitioner has exhibited that due to the newly adopted flood regulations by FEMA, that a practical development of a 2-story accessory structure, which is a completely common occurrence in Davis Island, as illustrated by the applicant with numerous examples, that the practical difficulty of developing a single-story accessory structure to work within the FEMA guidelines is not possible.
I'll second that.
Second by Ms. Long, and a vote please.
Excuse me, Kamaria Pettis-Mackel from the legal department. Before the members have the vote, can the applicant please come back to the microphone to acknowledge the condition that was placed in the motion and whether or not he accepts the condition?
Yes, I acknowledge the condition and I accept the condition as read.
Ms. Long?
Susan Long, aye.
Dustin Pastor, nay.
Brett Feldman, nay.
Leonard Tech, aye.
David Farrell, aye.
Okay, so we have a 3-3 vote. I believe we need 4 to approve,
No, you need.
or is it?
That's a tie, so
Yes.
that it
It
needs to
is.
go to the next agenda.
Oh, great. Okay.
And Mr. Sousa, can you just put on the record what the next, I don't know what the next, agenda,
Next
available agenda is.
Sorry. Joel Souza, Land Development, next available agenda is in May. I gave the calendar to Mr. Petschel.
Oh, I'm sorry.
Yes, May 11th is the next available spot.
And we would just need a motion to continue the VRB 2119 to the May 11th, 2021 agenda at 6:30 PM.
I'll make the motion.
I thought it was automatic.
Well,
Yes.
so that is right, it is automatically, so it would be continued to the May, I'm
March
sorry, I apologize for that.
9th. March 9th.
Is it May or March?
Well, you said next agenda or
The
next
next
available?
available agenda,
May 11th.
right.
So somebody would need to make that motion.
It's automatic, I
Okay,
apologize.
all right. Wonderful. Well, good news, bad news. You have been continued to May 11th. We're feeling very hopeful we'll have 7 board members by then, and this can't occur again. So, any questions, you can follow up with Joel during regular business hours.
Thank you.
Thank you, guys.
If you plan to give testimony today or speak, please stand. Raise your right hand. Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay. This is case VRB 2120, located at 410 West Francis Avenue. Mr. Sousa.
Yes, sir. Land Development, Joel Souza. Property is zoned RM16, residential multifamily. Property owners Brian Turnbull and Nettie Patel. Agent is Amy Holmes Joyner. They're requesting, applicant is requesting to reduce the rear yard setback from 15 to 3 feet, the west side yard setback from 77 feet to 3 feet. This is to build a one-story accessory structure, second unit with 2 parking spaces. DRC has reviewed this application. Transportation found that they need to be able to provide 2 parking spaces for this second unit. Applicant is calling it an accessory structure. Staff is calling it a second structure. They do have the density for 2 structures. His staff's belief that that's what they're asking for. So the setbacks is to a second dwelling unit. Let me show you where this is located. This is over a little bit south of Columbus.
Joel, we still have the old presentation pulled up. It has been repaired.
Something
Continue.
happened? Sorry. Okay. Start again. Property is right here on Francis Avenue, which is a little bit east of North Boulevard and a little south of Columbus. This is the existing structure. This is the survey that's in your packets. Existing house right here. Sorry about that. And this. Touchy. This is the proposal. They're adding a second unit right here on the south side of the property, right here. Transportation issue because they can only fit 1 parking spot in here, so they'll have to add some little bit more pavement up into this area, provide 2 parking spaces in the area. But they're going for the rear yard setback from 15 to 3, and the side yard from 7 to 3 right here for the second unit on the property. They do have the density for a second unit. That concludes my finding. Staff's here if you have any
Mr.
questions.
Sousa, why does staff say that it's a second unit?
Because that's what they, if you're, because they, for an accessory dwelling unit, you don't need parking. You do for a second unit.
Okay, but our notice here says accessory dwelling unit with two
Doesn't matter,
parking.
you're going for the setbacks,
Okay,
with the setbacks.
all right. Please state your name, address, and if you've been sworn, please.
Garrett Gilkey, 8603 East Adamo, and I have been sworn in.
Okay, you've got 10 minutes.
Thank you for your time. About a year ago when I met the clients that articulated, being new to Tampa, their appreciation for the historic nature of the Tampa Heights area. What we've seen in the last several years as that area has been gentrified is the onslaught of contemporary modern townhomes. Now, while the zoning affords the opportunity for multiple structures on one site, being RM16, the clients have a general dispensation and appreciation for the historic nature of their home. Their home was built in 1948. Now, while it was remodeled, and several of the elements do not accurately represent the profile relationships that you would see and experience with period-specific homes, such as areas like Hyde Park and other areas in Ybor, they do ascribe to the idealism behind the movement of craftsman-style architecture. With that being said, they have both their parents are getting older and they're moving to Tampa. The clients are, the homeowners are both, one of the homeowners is a cardiologist, the other is a professor at USF. Their desire in this unprecedented time of the pandemic is to be able to be more proximate to their elderly parents as they continue to get older, while not having or being forced to put them in a nursing home, while then also being able to exercise their talents and skill set at home to provide and take care of them. Now, while that is not a unique hardship to the location and to the site, it does articulate the, the preference in maintaining the nature of the a historic presentation for a site plan, and then furthermore developing we're considering an additional dwelling unit. So if this were to have been in Hyde Park, this would be considered an accessory structure, and we wouldn't have the constraints of the additional parking nor the setbacks. Now, what we have in this proposed site plan configuration is the structure with hopefully a reduction in rear and side setback to communicate a more period-specific nature of a site plan configuration for a historic home. If we were to have placed the structure inside the primary setbacks, it would not only affect the eve-to-eve separation required by code, but also would omit effectively their configuration of a backyard. So we believe that the general hardship for this project is the fact that we have, while it has been, from an exterior remodel standpoint, degraded from the historic nature to more of a modern application of craftsman-style architecture, they believe that tearing it down and performing, putting up condos would not be feasible. So this also has a scale that I think is relative and appropriate to the size of the home. So we're not chasing after a two-story accessory structure, while there's a lot of examples in the community
Pardon, can you zoom out a little bit so we can see that better?
So you can see the scale.
Right here.
Okay. So the home does not present a demonstrative scale in the front elevation. So the goal for us was to create a one-story accessory structure in the back of the home. As you can see, again, it's been a modern application of a stucco application on the exterior of the home. Does not represent the period-specific nature of profile relationships for a historic home. Now, again, while that is the case, and this is not the ARC, their desire is to communicate and build a site plan that would reflect a historic presentation. In the community, there's been a series of other VRB applications to give a reduction in rear setbacks and side setbacks. We have 406 West Francis, 2304 West Massachusetts, 409 West Park, 411 West Park. These are all accessory structures that fall within the setbacks, the primary setbacks. This is 410 West Francis. There's a 2-story accessory structure within the 3-foot setback. 410 West Francis, 209 West Palm. 213 West Palm as well. This is 317 West Francis, showing an alley access for transportation. And then this is 410 West Francis, 308 West Amelia. So again, while the nature of having family proximate to them is not in and of itself a hardship to the property, we believe that exercising the zoning for multifamily is affected by the nature of it being a historic structure and us not wanting to affect that historic nature. So our desire is to be able to align ourselves with what we would see more traditionally in historic Hyde Park in allowing for an accessory structure within those setbacks. That's it. Does that conclude your presentation? Yes. Does that conclude your presentation? Okay. Is there anybody in the audience who wishes to speak on this case? Please come forward.
Good evening.
Please state your name, address, and if you've been sworn.
Yeah, Neil Beckingham, and I've been sworn in, and we are the property owner at 412 Francis Street, West Francis Street.
You've got 3 minutes.
Thank you. So while we don't dispute that it's a good idea to build a second structure in the rear of this property, and certainly support doing that, we do object to the setbacks requested. We think they're unreasonable. For a number of reasons. One, so our property is a 1960s duplex. It's been multifamily, obviously, for 50 plus years. So the 2 backyards will be, in particular the one on the west side, will be unreasonably affected in terms of both vista and light by this property. We are considering what our options are in the future for this property. We may well look at developing it. It's historically been multifamily, so I suspect we will keep it that way. And if we were to do that and then look at a second structure ourselves for those 2 duplex halves, we're immediately going to have an issue. So having the structure 3-foot setback on the side, on our side, on the western side, seems a illogical choice. I did ask the developer why it was on that side, and he replied it was, he thought, due to a tree setback, but looking from the alley, I don't see what tree that he's talking about on the eastern side of his property, or the client's property. I don't understand the claim of wanting to do this on a historical basis. The front house, it's bungalow style, but it was completely redone in 2020. It's stucco, it's aluminium windows. It's not a historic structure. If they wanted, I would understand, and we support historic structures, but that's the vista from the street. So if they were wanting to do that, why would they not create more historic features on their front residence to then say, okay, we can justify why we want to claim historic reasons to do the back structure. I think safety is going to be a big issue and liability if they're wanting exiting out of that property onto the alley. Again, if we were to build a future structure on our property that exits the alley as a carport, you would be exiting with a big structure 3 foot from the corner in both the rear access or the rear direction and on the western direction. And so you're going to be exiting blind, and that's going to cause a safety issue in our view. So those are the main points. We don't think it's a common structure historically next to a multifamily property. We don't see that in the neighbourhood. And again, it's a modern house at the front, doesn't justify a variance based on that. There's some beautiful historic homes in that street. We would be supporting it if it was one of those homes, but it's not. Thank you.
Thank you. Is there anybody else that wishes to speak on this case? Seeing none? Oh, there is? Okay, come on up.
Hi, my name is Shonda Brown. I was sworn in.
And your address?
I'm sorry?
And your address.
Owner of 412 West Francis.
Okay.
So I just wanted to reiterate some of what Neil said with our concerns with we're not wanting, they're not to be, or not to move forward with building the structure. It's the concern of how close it is to our property and the hazards that would be presented with coming in and out of the back driveway that we might put there into the alleyway. I mean, it's a huge hazard. If you're pulling out of the driveway and you're trying to look left, you don't know if a car is coming. And for safety concerns, it's just, it is a big concern for us. Another issue is if they need to do repairs on that property, being 3 feet close to our fence line, I mean, how are they going to get around their property? They're going to want to request to come into our land and do those repairs. And it is a concern for us. And it also, if the property is so close to ours, or the structure is so close to our property, with our current tenants, it impinges on their privacy. And I think that's, a concern for anyone. Just trying to look at some of my notes, I apologize. And, I guess that's it. It's just more of a safety concern from, my viewpoint, from Neil's viewpoint that I want to express. Thank you.
Thank you. Is there anybody else that wishes to speak on this case? Seeing none, we will open it for board questions. I have a question for Mr. Scott.
Jonathan Scott, Transportation Planning.
Hello, Mr. Scott.
Hello.
You heard the testimony right now about the back alley and traffic and sight lines for the neighboring property. Have you guys reviewed this application in that regard?
Not in that regard. If they were to build a garage, I can see their points when they come out of the garage, but they'd have to meet the setbacks for their vehicle entrance. And, technically the other house there, they could have a fence, which we would see, so they have other things to consider as well. They have things like backup mirrors and so forth, but as far as that aspect, we haven't looked at it, but I can see their point about that. But technically, a neighbor could put a fence up right there. So when they design their garage, they'd have to meet vehicle entrances and consider the site and so forth. And it might be if they build the fence themselves as well, they would want to keep it so they could see out, but those are all the things they would consider when they built the new structure themselves, not really an issue as far as this is concerned.
Okay.
That we looked at.
Is there any other questions for Mr. Scott before he makes the long trek? No? Okay, thank you. What other board questions do we have?
Not for Mr. Souza, maybe. Can you remind me what the setbacks would be if this were zoned as an accessory structure?
Joel Souza, Land Development. Yes, if this was an accessory structure, you'd be dealing with 3-foot side, 3-foot rear, and 5-foot EV separation from the main structure.
Okay. And can you please help me understand why this is not being zoned as an accessory structure? I'm not sure that I quite followed the reasoning.
Accessory structures don't require parking. It is staff's belief that when you ask for primary structure setbacks and you're providing parking for that accessory structure unit, that it's basically becoming a second unit. You've set it up. Other than a kitchen, it's meeting all the definitions of a second unit.
So you said that they asked for primary structure setbacks?
Yes, they did. If you look, they're going from 15 to 3 and 7 to 3, which is the primary rear and primary side of the multifamily zoning district.
Okay, so if they were to apply for this construction, so I guess I'm trying to figure out, it's not staff who directed the applicant to apply for this variance from 15 feet to 3 feet. It's the applicant who
Correct.
requested this.
This is correct.
And does the fact that this, in theory, if this were zoned as a primary structure, what does that mean, practically speaking? Like, could they subdivide the property and sell it separately?
Joel Souza Land Development, no, they can't. They'll probably have to sign a zoning covenant because they're sharing the lot. So these two dwelling units will share this parcel together in perpetuity. Very much like a duplex setup. They do have, that's why staff, they're calling it accessory structure. We're calling it an additional dwelling unit.
Joel, when they go to construction drawings, will they be allowed a separate water tap and sewer meter?
This will, Joel Souza Land Development, yes, they will be allowed to do so. They have the density for the second unit.
So they'll be allowed to put a full kitchen in that thing?
Yes, they will.
Just more follow-up on this, Joel, I'm sorry. So is the driving factor because they're allowed to do those things that this becomes a second unit, a second living unit as opposed to an accessory structure? Because again, the setbacks that they're asking for are essentially accessory structure setbacks, right?
No, these are primary structure setbacks he's asking for.
Right, the change, but the setbacks that they're actually asking for, you said just a moment ago, if this were an accessory structure, it's 3 feet and 3 feet, right?
That is correct.
Okay, and it's not a size-driven thing, right? Like it's not the square footage of the unit itself that's turning it into a second living structure, is that correct?
Correct, that's not the size.
It's not the size, it's the fact that the applicant wants to put, or wants the ability to put a second power meter, put a full kitchen, those kinds of things in there. Is that correct?
Could you phrase that slightly differently?
I don't know. I have no idea if I can phrase that. I'll try. So if it's an accessory structure, right, if let's assume, and again, I don't know, I've heard what you said in terms of the applicant says they're coming in and saying we want to move from 15 to 3 and from 7 to 3 feet. But if the applicant said, no, I mean, the applicant did say that they believe this is an accessory structure, right? But if it were an accessory structure, are they allowed to put a full kitchen in there?
If they were an accessory structure, they wouldn't be here for a variance setbacks.
No, that's not the answer to my question at all. My question is, if this is an accessory structure,
Yes,
if
sir.
this is considered an accessory structure, are they allowed to put a full kitchen in there?
Not without a special use permit.
Okay. And they also would not be able, as Mr. Farrell questioned you, they also would not be able to put a separate power meter out there, or a water meter, things like that, correct?
That is correct.
Okay. All right, I think I understand. Thank you.
Yes, sir.
Can you, question, excuse me. Under that zoning condition, can you limit the, you couldn't warrant in the could you warrant a conditional approval that it was to be set up to tie it into the main power feed and the water line as an accessory structure, or do you?
Joel Souza Land Development, we don't have ability to make them do that.
You don't have the ability
This
to do
board.
I have a question for the applicant. Can you please help us understand why you guys requested the primary structure setbacks? I mean, maybe let's start with that.
So it is it's a historically consistent application, and it's a way to, in Hyde Park, to allow for extended family to stay to live, and so it's predominantly to have the extra space for their family to live, whereas inside the primary home, which is not large, they don't necessarily have the room. So unlike condo development or townhomes that are maximizing the square footage of the lot and going up to 35 feet and arguably destroying the nature of our community. This is a way for us to exercise that same usage while also being appropriate to the scale of the home. And
I think the question is, can you not do all those things you just said with the accessory structure, and why not?
Because of the kitchen, because then it would require a special use permit. And so
Okay.
the preference is for the space to be independent for their family. And so they don't necessarily have to be in each other's space every day and cooking.
Is it more onerous to apply for a special use permit than to come before the variance review board?
I don't think so. I think that we just preferred to seek after the variance. I think that it's indifferent to us whether that's the consideration. It's just the path we decided to chase after. But yeah, we don't have a particular agenda in the the future opportunity to make it necessarily multifamily. I think that's not the goal.
I have a question for for the neighbors that were objecting. And so if you could step aside. And it doesn't really matter who answers these questions, because you both raised some good points, some strong points, but I want to talk a little bit about what we just heard.
Thank you.
A lot of the points that you raised, traffic problems, privacy concerns, the being very close to your property. Those are all valid and legitimate concerns. But the issues that were just raised are if this were considered an accessory structure, meaning that they decided not to put a second kitchen in there and just built this structure as is in exactly the same dimensions and exactly the same location, they wouldn't need to be here.
Yeah.
They would be able to build it in exactly those locations, and the objections that you had would be objections nonetheless, but you wouldn't be able to prevent them from building it in that fashion. Can you talk a little bit about those concerns in light of that, so that I can understand what the objections are?
Yeah, thanks. So, I mean, I understand. So, for example, on the one half of the duplexes on the eastern side, we have a shed that is an accessory structure, and it's 3 feet from the neighbour's property. That property is I think it's a 1929 or so older property, and that property is 3 feet. So it's historically grandfathered in, built 3 feet from the property line. So one point is I'm well aware of having structures very close because we've got it on the other side. I guess in my mind, so when I think of an accessory structure, I think of like a shed, and that to me is very different than something that someone is going to be full-time residing in, because you've got constant power, you've got lights will be on, you've got people coming in and out constantly. That is very different in my mind than a shed. I think it's also, to me, pertinent if it was the other side, if it was the eastern side and it was against an area that was, or the next property was a single family, that to me is different than being next to a duplex. In a duplex scenario, you've got 2 skinny yards. So the duplex half on the western side, their yard they've got a small yard to start with, half the normal size, and they're looking right at this structure. That to me is different than if it was a single family. So I guess I'm coming at it from that angle. I don't know, because I haven't seen plans. The first we heard of this was the notice in the mail, and the developer wasn't all that helpful. I don't know if there's windows overlooking the yard, that would be another concern, but the fact that there's going to be someone in there permanently and coming in and out of that alleyway permanently, that to me is the difference.
And that makes sense. Thank you. I appreciate that. Thank you for the clarification.
Are there any further questions from the board? Seeing none, got 3 minutes for rebuttal.
Thank you. Just a couple things to just quickly annotate about the opposition. So one thing that is unique to this site plan, which you'll see, is the side in which we're chasing after for the setback, as you can see, currently has a fence that that the gentleman who's opposing our project has. So he has a fence that's 3 feet onto the property line of our homeowners. So theoretically, when we look at the marketability, the future development of something, that fence, theoretically not moving, is in favor of his development. The couple other points that I think are worth bringing up is interpretation of a shed is relative. The man who is opposing this variance lives in Hyde Park and communicated that to me. I'm one of the biggest builders in Hyde Park, and there's no question or debate as to what an accessory structure is considered. Every home, if not every other home, or the majority of homes, have single-story, if not two-story accessory structures. So its articulation is and should not be debated. The windows. If we're going to be developing condos in that neighborhood, which again completely takes advantage of the nature of that and the character of that neighborhood, we're going to have windows at 35 feet. So that argument in and of itself does not justify the claim or the defense or the opposition against it. Again, I think as a man who lives 4 houses down in that neighborhood, I've seen firsthand how developers have, in a greedy way, come into our neighborhood and take advantage of the low-income housing and having the capitalistic opportunities to develop multifamily, and exploited the gentrified men and women who are living in those condos and now have to move out because they're going to put up larger townhomes. So there's a fundamental philosophical reason behind why we're chasing after creating these consistent and historical relationships in our community. It's so that we can preserve the nature of our community and protect the people in our community. Yes, we have an issue with needing urban infill, but if we do it without dignity, if we do it without keeping the resources in the community, and we hire contractors that take the money into different communities, and we're not cultivating the people in that community, we're doing a disservice. If we're going to develop, we need to develop with purpose. We need to develop with integrity. We need to develop with dignity. That is my main goal, as again, one of the larger builders in Hyde Park, to use my gifts and my skills and my resources in a neighborhood that arguably needs to be protected. So while yes, this is a multifamily district, and yes, there are the constraints and the issues associated to the additional living space and its reduction and those concerns, nothing stands against what's historic. Thank you.
Okay. We will close the public hearing now and open it for a motion or board discussion. I'll just say from my viewpoint, the purpose of setbacks is for the benefit of the neighborhood and the neighbors. In this case, the most immediately affected neighbors are objecting to it. And it seems there are other avenues to achieve this project with some modifications, so I'm inclined to not support it for those reasons. It could be an accessory structure and go about a different path. It could go for a special use permit, but as proposed, it is encroaching 12 feet into a setback and 4 feet into another, and the immediate neighbors don't support it, so I don't either.
I kind of feel differently, mostly because this, to me, looks exactly like an accessory structure. In fact, based on my understanding of the application, the only difference between this structure and an accessory structure is the fact that there will be a kitchen inside, and I guess perhaps separate meters. So, you know, from a practical perspective, I am having a hard time. I sympathize with the neighbors and completely understand their position, but in light of the fact that it seems to me to be 6 of one and half a dozen of the other, I'm inclined to support the request.
Just note that a kitchen is a notable difference, because a kitchen implies that you could live there permanently, which was exactly the neighbor's point. So.
And you are allowed to have a separate water, and there would be no zoning enforcement on the water and sewer.
I mean,
There would be no,
fair point, that's a
it
fair
would be
point.
hard, that, the one thing about the accessory structures is that zoning is set up so that those things don't allow you, that has to run off the same power meter that the house does, and you have to run the sewer and water through the same, you don't get to separate it out, and that's really where the difference is here. I think it's mostly the zoning.
Lynn Hurtak, I'm having trouble finding the hardship. Can anybody help me with that?
We're not gonna make the hardship case for them. Now we're in a closed public hearing, so he stated what he thought they were. But, I mean, if you wanna recount them, Fred.
Yeah, I mean, what I heard for hardship was that, you know, they're looking at trying to preserve the historical character of the property. You know, the neighbor did point out that this is not, it's a remodeled home, and though it looks of historic character, it's not quite the same thing. I mean, I understand what they're saying. I mean, to me, the point that Ms. Hurtak, that Ms. Walker made, is the one that I'm wrestling with, which is if you don't put another kitchen in there, and yes, I understand the issues of running it through, you know, you can run plumbing there from the main structure. The only difference is one is easier to rent out separately than the other, right? But realistically, from where this is placed, from the perspective of where this is placed and how it sits on this property, you could put this exact box there in the exact same way, as long as you call it something different and you don't put that kitchen in there. And they can do exactly this and then go for a special use permit, and you know, you get to the same place if they're granted that special use permit.
I believe Mr. Sousa said though that parking is the difference.
Well, but the parking follows that, right? It's not like you're saying, I want to park
It
cars.
follows a primary
No,
use.
yeah, but what happens with the driveway, as soon as you go to building application and you want that thing's 3 feet off setback, off the rear property line, and you have a garage door there, transportation's gonna
Yeah.
throw up a red flag and say no, because you don't need a visibility triangle onto the alley. So how do you get past that once you approve them on?
So what I was
Do we have a garage
understanding,
door?
what I was understanding was that with the accessory use, you wouldn't have the allowance for parking. That's because it's primary.
Well, yeah, it wouldn't be required, so there would be more
Right.
street parking.
Well, on-site parking
No, my
and
point is it
and
makes it less
accessibility
livable.
to an alley are two different issues.
My point is that the accessory structure makes it less livable. You can't have separate utilities, you can't have the parking.
But
It'd
they
be
could
less
install
livable.
the parking still.
Just making a point.
Yeah.
Right, but the applicant is challenged by the fact that they have to put more parking in there. They didn't ask for the parking. It came with the way that the application is being interpreted.
Which makes it more permanently livable.
Yeah,
That's my point.
yeah.
And if you put a garage door on the rear, despite, Joel, how does that work? If we approve a 3-3, just for argument's sake, if it were approved, and then it goes to Jonathan, and you have a visibility issue, what happens then?
It still has to comply with permitting. It still has to comply with permitting. We don't get to override permitting. Just,
So at that point then, permitting can tell them that they would have to move that structure
yeah,
in one direction or the other in order to make that visibility.
that is a potential outcome. So does anybody want to make a motion?
I'll make a motion. We'll see what happens with
Go
it.
for it, Ms. Long.
Okay. I move that the variance request for case VRB 21-20 for the property located at 410 West Francis Avenue be granted as depicted on the site plan presented at the public hearing for a reduction in the rear yard setback from 15 to 3 and a reduction in the west side yard setback from 7 to 3 with alley access. Based upon the applicant presenting competent and substantial evidence in the record, and at this public hearing of an unnecessary hardship and practical difficulty When considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that the property is zoned, multifamily 16, I believe it is, and there's one structure on it currently. They have the zoning appropriate for them to add another structure, which is what they want to do, in order to make it functional. They have requested a second dwelling unit, and because of the second dwelling unit, they're required to add 2 parking spaces and to get these variances. And that becomes awkward. They have access through an alley to this particular place, and they're trying to maintain the historical appearance of the neighborhood in Tampa Heights. Okay?
Sam Walker, second.
Thank you, Ms. Walker, and a vote.
Okay. Long, aye.
Dustin Pastor, nay.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, nay.
What's the score?
No.
Nope.
Yep.
Do that.
You're just gonna take a vote.
It's his call.
What was that? Aye. David Farrell, aye. Motion's approved 4-2.
Cool.
And can be appealed to city council within 10 days.
Didn't we approve it? Why would they appeal?
What was that, Ms. Post?
Just a quick recess, please.
Okay, let's take a 5-minute recess.
But now I guess you have changed your mind. You said you once said love me, but now I guess you have changed your mind. Why don't you reconsider, baby?
Brett's questioning.
Give
Brett's
yourself
questioning
just a little more time. When I was just a little boy like you, I wanted to do jabba jimbly boo. The girls wanna stay and the boys wanna play, so let's rock and roll till the break of day. Yes, yes, I didn't cry. Yes, yes, and you know why. Yes, yes, I know when and what. Yes, yes, no if and or but. I was looking for joy. Yes, 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 when I was a little bitty boy. Biggest fool there ever was. I let you go. Now I can't survive without your touch. I need you so. But baby, all you got to do is tell me that you need me too. I hit the ground running. I hit the ground running. I hit the ground running back to you. Oh, and I'd rather die 1,000 deaths than to lose your love. But now I'm drowning in my loneliness. I can rise above, yeah, I can. Well, just forgive me this one last time. And tell me, baby, you're still mine. I hit the ground running. I hit the ground running, baby. I hit the ground running back to you. All is right, baby.
Will you please stand and raise your right hand? Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
Okay, this is case VRB 2121, located at 1209 East 25th Avenue. Mr. Souza.
Yes, sir. Property is on RS50 residential single family. Property owner is Paramount Court LLC. Agent is Blake Frazier. They're requesting to remove a 37-inch live oak tree off the property. DRC has reviewed the application. Natural Resources finds it consistent as long as they mitigate it permitting for a replacement tree. Let me show you where this property is. A little bit north of downtown. This is the zoning aerial. It's in your packet. 12th Street going north. This is the property right here. is touchy. This is the property, appears to be vacant at the right now. Appears to be a couple large trees on the lot. This is Owen Williamson's review from Natural Resources. These are the proposed, this is the location of the trees and the location of the buildable area that's been provided by the applicant. It's also in your packet. They show a variety of different setback requirements for different locations. As I scroll through these. This is the elevation of what they propose to put on the site. And I'm just rolling through the application. This is just the TRZ requirements. Mr. Williamson's here if you have any questions regarding the tree.
Okay. Applicant, please state your name, address, and if you've been sworn.
My name is Blake Frazier. I live at 3710 West Cass Street, and I have been sworn in.
Okay, you've got 10 minutes to present.
All right. As Joel mentioned, we are looking to remove a 37-inch live oak tree in order to guarantee the ability to construct a new single-family home. We believe that the location of the tree being just outside of the tree removal zone and the lot's shallow dimensions to create a hardship on the lot. As you might have seen in our application, we provided 3 alternatives on the where we could place the single family home. So the tree in question is just right outside the TRZ zone. I know it's probably hard to tell from the color on this, but the buildable pad is the dotted blue line, the typical setbacks for this neighborhood, and the red would signify the TRZ zone. The tree's trunk is within 1 or 2 feet, give or take, from that TRZ zone. And then the center of the trunk would be maybe about 3 feet. One important thing to mention about the lot is it is a 52 by 90 foot lot, which is substandard to the typical RS50 lot size. In our application, we showed some examples of what a typical footing would look like for our for one of our houses. This would be a 2-story just because of the lot size. Typical footing for this application would be a 10-foot deep by 16-inch wide. An alternative foundation method that I have used in the past before is a helical pier that ends up having a 20 by 20 by 12 inch deep pile cap set on top of it to create a pier and lintel system to avoid the roots as much as possible. The foundation that was shown here shows a better example of it. Like I mentioned before, this is an application that we had used before. This is not, in regards to this particular tree's location, size, or anything of that nature. So on our second site plan, we showed the ability to reduce our front setback by 25% and our side setback by 1 foot. Using the alternative foundation method, you can see the foundation using kind of the helical piers here. And in this, we noticed that the closest point to the tree's center would only be about 16 inches difference or 15 inches different from a typical foundation meeting all the setback requirements. So we noticed that there was not going to be too much of a difference between the construction methodology. Secondly, we looked at, in the application, we noticed the alternative placements, orientations, or size of the houses really did not change potential impacts to the tree. I did a study of all the new home construction that had happened since the beginning of 2010 to the middle of last year that showed that there were approximately 211 new single-family homes that had been advertised or sold within MLS. And in that, there were about 83 unique floor plans out of that 211. The average footprint of those floor plans was 33 feet wide by 55 feet deep. The proposed floor plan that we have, put on this is a 35 by 44 foot two-story home. Much less than what the average floor plan would have been in East Tampa. So whenever we filter down those results to the floor plans that actually would have fit this lot and its setbacks, because it is the 50 by 90 foot lot, we found that there was only there was only 22 floor plans that would fit the setbacks of this particular lot, and that average dimension went down to 31.5 by 45.5 deep. So we fit just inside that average. And then we filtered that down even further to what would actually fit within our 30 by 44 foot plan, and it became only 4 plans. And of those 4 plans, there were 2 plans that either had no garage or a 1-car garage, which would obviously alter the impact on the lot, the other trees on the lot that we would intend to preserve. And then, a 1-car garage would probably not be able to encroach the front setback more than 18 feet because the code states that you have to provide that secondary space of 9 by 18. So therefore, there was really only 2 plans besides ours that would fit this lot. So we did not find that to be any sort of problem with removing the tree. And then we proposed a third site plan as well, which we referenced section 27-284 of the Development Code, specifically table 284.2.5, that says only on TRZ lots a grand tree that has all or the majority of its trunk determined at the DBH within the TRZ may be removed if the footprint of a proposed principal structure building or addition of heated floor area to an existing principal structure building conflicts as shown on the, I apologize. As shown on the construction plans of the relating building permit within a 15-foot radius of the grand tree's trunk, said radius to be measured outwards from the edge of the trunk at DBH. So, as this tree does not fall within that TRZ zone, technically we are not able to remove it without, the additional permitting. But if we took that supposed 15-foot radius which we would have to get a reduction from the typical 20-foot radius, we looked at where the house placement would have to be from there. We still use the 1-foot reduction to the side setback, but to get outside of that 15-foot radius of the root zone, we had to decrease the front setback significantly to 7.5 feet from the front property line, which on a street like this particular one, where there's not a large public right-of-way, our front facade for our garage would only be 9 feet from the public sidewalk, and then 13 feet 4 inches before it entered the road area.
You got 1 minute.
So we figured that this position of the house would actually be a larger endangerment to the public safety, as cars trying to pull out of the garage would not have a clear line of sight before they entered the public sidewalk and potentially the public right-of-way or the street. And that, basically concludes my presentation. I'd be happy to answer any questions about the foundation methodologies or placement of the houses.
Thank you. Is there anybody in the audience who wishes to speak on this case? Seeing none, board questions. Seeing none, rebuttal. You have 3 minutes if you need it.
I'm good.
Okay, thank you. We will close the public hearing and open it up for a motion or board discussion.
I move that the variance request for case BRB 21-21 for property located at 1209 East 25th Avenue be granted as depicted on the site plan presented at the public hearing for removal of a grand tree based on the petitioner meeting the burden of proof with regard to the 6 factors for determining tree removal as set forth in section 27-284.2.5 F4 of the city code for granting tree removal. Specifically, that the evidence provided in the record showed that alternative construction methods that could be utilized to preserve the tree would still require a significant change in the location of the structure, and the applicant presented alternative locations and configurations of the house, but the structure would still be unworkable given the average size of structures within the area and the significant reduction in the front setback of the house could cause health and safety concerns for cars that are entering and exiting the driveway, as they wouldn't have a clear line of sight to either the sidewalk or the public right-of-way.
I'll second.
Second, Ms. Long, thank you. And a vote, please.
Susan Long, aye.
Dustin Pastor, aye.
Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, aye.
David Farrell, aye.
Okay, your motion's been approved, 6-0. Have we already sworn in the last case, Brett? Yes, perfect. Case BRB 2122, located at 113 South Glen Avenue. Mr. Sousa, please.
Yes, sir. Parcel zoned RS60, residential single family. Property owner is Russell Miller, who's also the agent for Home Love Construction. The request is to reduce a side yard setback from 7 feet to 5 feet to match an existing home that was built back in the 1940s for a new master suite. DRC reviewed the application and no issues. Let me show a picture of the structure, location. This is what the house looks like now. This is the location right here on Glen. It's a little bit south of Kennedy, a little bit east of Himes Avenue. It's the neighborhood right here. This is the site plan that's before you tonight. This is Glen Avenue, and the applicant appears to be filling in the existing structure and matching the existing structure with the setback. Staff, see if you have any questions.
Thank you. Applicant, please step forward. State your name, address, and if you've been sworn, please.
Right, I have been sworn. My name is Russell Miller. I reside at 8033 Paper Bark Lane, Port Richey, Florida, 34668.
Okay.
And a correction to the record is I am not the owner of the property. That was a
But you are the
misprint.
applicant and the agent, or just the agent?
I'm just the agent
Okay.
for the property. The owner is here in the room tonight.
Okay. Ms. Pettis, do we have any issues with that from a notice perspective?
I believe it is correct on the application, just to.
Okay, so maybe it's
Mario
just,
Pettis-Mackel from the city attorney's office. As long as he's the record, that properly documented that he's the agent, we can proceed.
okay. You've got 10 minutes to present.
All right. As to item 1, the location is the only practical location for an addition for a building, for a home built in the 1940s, and there is no other viable option. As to 2, the homeowner has recently required to be working from home and need an office space that will be created by building a new master bedroom. The footprint of the existing home was not created by the existing homeowner. And as to 3, the existing house, as well as every other house in that street, are 3 to 5 feet from the property line. The addition is an extension of the existing wall lines. The new addition lines up with the existing house, which is 5 feet from the property line, and should cause no injury or health and safety or welfare of others. The neighbor on the affected side of the home has provided a statement that they are in agreement that the variance should be granted and that the addition will not interfere with them. As to 4, the existing house, as well as every other house on the street, is 3 to 5 feet from the property line. The addition is an extension of the existing wall lines. The new addition lines up with the existing house, which is 5 feet off the property. The addition will not be visible from the street. B, completing the addition on this home as drawn is in harmony with the LU policy 9.5.1 to provide attractive houses to the households with children. This home is currently a 2-bedroom, 1-bath home. Adding a 3rd bedroom and a 2nd bathroom will allow for a multi-child family and to feasibly occupy the home. Also, LU, to the same policy, protect low-density single-family areas that provide opportunities for home ownership that are attractive to households with children and other residents, that provide residents with the privacy and open spaces accessible to residents. C, the addition is matching the existing architectural style of the home, and is the street-facing side of the home will maintain the home's traditional style. The addition will allow for the roof lines on the rear of the home to be more continuous and create a more uniform appearance, improving the overall look of the home. The following addresses the Gray Gables neighborhood encroach on the structural setbacks in similar fashion. There's other homes there that are listed, 112 South Glen Avenue and 215 South Glen and 210 Gunlock Avenue all have similar setbacks. Allowing for the, as to 5, the room addition is in line with the existing exterior walls of the home and will not be visible to the neighborhood at large. The homeowner would continue to endure impact from COVID-19 with the additional demands placed by working from home. In addition, the homeowners have a new child added to their family that was just born in this November that will soon be very interested in office equipment and paperwork. And that that's the end of what I had to say.
Have you submitted your letter of support to the record yet? And if not, could you submit it now?
The neighbor's letter?
Oh, the neighbor's letter, yeah, okay. It's in the form of an email.
Kamaria Pettis-Mackel from the city attorney's office. The agent has one copy, so I'll just show this on the Elmo. But if you want to just explain who the letter is from.
Okay, it would be the neighbor on the affected side of the building, or the structure. So that would be to the south of the house. And, yeah, that's.
Okay. Does that conclude your presentation?
That does conclude my presentation.
Okay. Is there anybody in the audience that wishes to speak on this case? Seeing none, we'll open it up for board questions.
I have a question. Did you address the neighbor's concern about water?
Yes, ma'am. Basically, the site plan that we presented to you does show the flow of water, that the property does slope towards the street. There is no concern for water going onto her property. Further on the plan, that they have agreed that we could put a curb in there along between the properties too, to help prevent any water flow that may come over there that, during a heavy rain or something like that as well. So, but no concern for water. She's not concerned any longer.
Thank you.
Are there any further questions? Seeing none, you've got 3 minutes for rebuttal if you need it.
No, sir.
Okay. We will close the public hearing and open it up for a motion for board discussion.
I'll make a motion. I move that the variance request for case VRB 21-22 for property located at 113 South Glen Avenue be granted as depicted on the site plan presented at the public hearing for a reduced side setback from 7 feet to 5 feet with an encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence in the public record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that this plan, this addition will follow the lines of the house that are already there, and the setbacks are common in the neighborhood.
Susan Long, I'll second that.
Thank you, Ms. Long. And the vote, please.
Vote Susan Long, aye.
Dustin Pastor, aye.
Brett Feldman, aye.
Sam Walker, aye.
Lynn Hurtak, aye.
David Farrell, aye.
All right, your motion's been approved, 6-0. And we are adjourned.
No further business tonight. Now, next month, we have